Good morning. It is so good to see you all here in person this morning on this beautiful sunny morning in St. Louis. We're going to go ahead and get things started. Welcome to St. Louis University School of Law. Welcome to the 2021 Richard J. Childress Memorial Lecture and Virtual Symposium. And a special welcome to all the folks who are viewing the live stream of this lecture and symposium. I understand we have about 500 people who have registered for the online version of this, so that's really terrific to hear. Even though you're not here with us in person, you are very welcome as well. And I look forward to the day when we can connect in person. I'm William Johnson. It's my honor to serve as Dean for this SLU Law community, and it's my honor to welcome you here today to our very exciting Childress Lecture and Symposium, Critical Race Theory in the Law. The Childress Lecture and Symposium is the premier academic event of the year at SLU Law. It commemorates the numerous contributions former Dean Richard J. Childress made academically, socially, ethically, to benefit the School of Law and the community at large. The Childress Lecture and Symposium always offers a really terrific opportunity to come together and exchange ideas, challenging one another, listening carefully and thinking deeply in the process, and advancing our understanding of law and policy and systems. This symposium, Critical Race Theory in the Law, offers an especially important opportunity to do just that, as our experts address an essential topic that has garnered quite a lot of attention recently. The schedule for the day looks fantastic, and there are several people who deserve recognition for that, including in particular all our remarkable St. Louis University Law Journal students. I want to give special acknowledgement to Dylan Ashdown, the Childress Symposium editor, who's worked very, very hard on this symposium. The convener of the symposium is Professor Chad Flanders. Professor Flanders is a fantastic scholar, and I'm sure you all know that, but he's also an excellent teacher and has been recognized for his excellence in teaching, and he happens to be a terrific colleague as well. So my thanks to Professor Flanders for working so hard with the students to pull this all together this morning. I also would like to thank my staff colleagues, Susie Lee and Julie Orr, who do a lot of the unseen work that makes a symposium like this come together. They deserve credit for their tireless efforts, and they have my gratitude. And finally, without our speakers, there is no Childress Lecture or Symposium, and the lineup of speakers today is terrific. And my thanks to each of the speakers for your time, for your insights, for your contributions to the conversation. And I am especially grateful to our keynote speaker, Dean Angela Onwuachi-Willig. Dean Onwuachi-Willig, I know how very busy you are. It means a lot to have the benefit of your words and your wisdom this morning. Thank you for being here. And thank you for your incredible national leadership as well, which has been truly inspiring to me. I'm grateful for all you do. Dean Onwuachi-Willig will be formally introduced in just a moment by my colleague, Associate Dean for Research, Miriam Cherry. But first, this year is a special iteration of the Childress Lecture and Symposium, because this year we are thrilled to offer this lecture and symposium in cooperation with the new Department of African American Studies at St. Louis University. It is my hope that this is the first of many collaborations between the School of Law and the Department of African American Studies. The chair of the department, Dr. Christopher Tinson, a truly impressive scholar and university leader, is here this morning, and I'd like to turn it over to Dr. Tinson to add his own words of welcome. Thank you all for being here. Welcome to the Childress Lecture and Symposium. Please join me in welcoming Dr. Tinson to the podium.
Good morning, everyone. Good morning, everyone.
Good morning.
One of the things in African American Studies, we actually talk back, to one another. Thank you, Bill, for your generosity of spirit and your unflinching commitment to justice. Thank you to Chad for your diligence in pulling this all together. And thank you to everyone who's had a hand in this occasion. I'd also be remiss if I failed to mention our dear and recently deceased brother, Jonathan Smith, Dr. Jonathan Smith, who was our VP for Diversity and Community Engagement, passed away on Juneteenth of this year. I always want to invoke him for his brilliance, his remarkable curiosity, and his gentle humor. As we're a Department of African American Studies after 45 years as a contract major, then an institute, then a program, this is indeed a historic occasion. I'm not even sure that there's been any African American Studies professors to ever come and do a presentation at the law school. This is the first of many. So I'm looking forward to our collaboration. And I thought that it would be important, since you don't know who I am, just to give a context for some of the things that I imagine we might collaborate on. And as you know, African American Studies has a long history in the academy, almost over 50 years as an active area of study in the United States Academy, but it's actually over 100 years in terms of people doing this work independently, at least. And good to see my brother Brendan back there. So I want to just jump right in real quick, and I won't speak long. But since you don't know who I am, I want to give you a context of some of the stuff that we do. The failure of legal protection against the state-sanctioned, group-differentiated, extra-legal, geographically bound vulnerability to premature death contextualizes Black life in the United States. This definition of racism, gifted to us by the radical geographer Ruthie Gilmore, captures the political economy of Black life and Black possibility. Moreover, it represents an indictment of the political, economic, legal, cultural, and also educational institutions that constitute American society. Her case study was the expansive carceral landscape in my home state of California. And her definition provides important texture to an otherwise often mentioned but woefully under-interrogated notion of racism. Gilmore's definition is an heir to William Patterson, the William Patterson-led Civil Rights Congress, who in 1951 issued the We Charge Genocide petition, which was documentary evidence of persistent, chronic, quotidian forms, patterns, and practices that led to premature death of thousands of Black people. Among its signatories were W.B. Du Bois, names you might know, Charlotta Bass, Louis Burnham, Mary Church Terrell, and the great Renaissance man himself, Paul Robeson. In our day, the struggles for justice abound. Struggles over indigenous lands, the rights of the long deceased, whose bodily images and remains continue to enrich American institutions, whether we're thinking about Harvard University, in the case of Louis Agassi's photographs of the enslaved, or the University of Pennsylvania's holding of the MOVE remains from the MOVE bombing in 1985. Only recently were those remains returned to the family for proper homegoing. We can think about cold cases of the Civil Rights era, the carceral legacy of the Black Power era, the Atlanta child murders of the 1980s, the loss of Black people's land, the resegregation of schools, reparations for the descendants of the enslaved, and more. Thankfully, there are organizations such as the African American Policy Forum, Action St. Louis, the U.S. Human Rights Network, who are here to show us that this work continues, that this work is important, and that there is still justice waiting to be had. These organizations are part of the transformative resistance strategies that Derek Bell talked about, which depends on our interdependence and can inspire our collective survival. So building lasting relationships with SLU Law and the Department of African American Studies can enliven and inform, but mostly importantly, plant the seed for a just future for Black and brown people in the St. Louis region and beyond. Thank you again to Bill, and may your example be multiplied. Thank you all. And without further ado, please welcome Professor Miriam Cherry, who will introduce our speaker. Thank you.
Thank you so much, and thank you to all who are here and who are joining us via webinar. Welcome. So I'm the Associate Dean for Research and Engagement here at SLU Law, and I'm delighted to be able to provide the introduction to our keynote speaker, Dean Angela Nwachi-Willig. Dean Angela Nwachie-Willig is a graduate of Grinnell, the University of Michigan Law School, and she received her PhD from Yale University. She has taught at the UC Davis Law School, the University of Iowa Law School, and at Berkeley Law. And she is now the Dean and Brian Roth Gallo and Ernest J. Gallo Professor of Law at Boston University School of Law. Dean Angela Nwachie-Willig has published in many esteemed law reviews and journals, including the Yale Law Journal, the Virginia Law Review, and I could go on. She is also the author of the book, According to Our Hearts, Rhinelander versus Rhinelander and the Law of the Multiracial Family. Essentially, she is a powerhouse scholar in the areas of critical race theory, employment discrimination, and family law. She is a newly elected member of the College of Labor and Employment Lawyers and the American Academy of Arts and Sciences. Personally, I have known Angela for 20 years now. We met while working at the same law firm in Boston, and then eventually started law teaching at the same time. Angela has been a friend to me personally for the past 2 decades, and she's also been a tremendous friend to our program of instruction here at school at SLU Law. I will also add that I could say much, much more about our keynote speaker's many accomplishments, but I was told by Professor Flanders to keep this introduction brief so that we can actually hear from our speaker. So today, Dean Angela Nwachie-Willig will speak with us about #CRT, how critical race theory and technology has enabled today's social movement for racial equality, a very important topic. Please join with me in a round of applause for our keynote speaker.
So first, thank you so much, Associate Dean Cherry, for that kind introduction. It's always, of course, a pleasure to see you. And Associate Dean Cherry is right, we go way, way back. And what she didn't tell you is that we met at working at the same law firm, discovering that we were sort of both undercover wannabe academics. And that we actually shared a room at this conference there's something called the Meat Market Conference, where you go and you run around to different rooms and interview with different schools. We shared a room at that conference, a hotel room, and commiserated while we were engaged in that process for a weekend. So thank you, Miriam, very much. So in addition to Associate Dean Cherry, I want to offer a few more thanks, and I want to repeat some of the things that were offered, but I've benefited, of course, from so much work that so many people put into this symposium and lecture, so I want to make sure that I thank everybody. So first, I want to thank you, of course, for your presence at this lecture and symposium, and for being willing to engage in these issues and being willing to hear about important topics of race, racism, and law, all examined through the lens of critical race theory. I want to thank Susie Lee for all of her work in making my travel and visit arrangements, as well as my colleague back at BU, Bridget Carney, so that I could arrive here safely, so that I could be a part of this really wonderful symposium. I want to express my gratitude to Dylan Ashdown and the editors of the St. Louis Law Review for all their hard work in organizing this symposium and lecture. And I want to thank the law faculty for their hospitality, their good company, their great questions and insights about my research yesterday. Actually, not just the law faculty from public health and other departments, African American studies, other departments during a faculty workshop yesterday. And I want to express my gratitude to my amazing colleagues who've taken time out of their incredibly busy schedules to discuss critical race theory and the law today. Dean Mario Barnes, Dean Danielle Conway, and Professors Anthony Farley, David Nevins, Ngozi Okedegbe, and Christopher Tinson. And I especially want to thank Dr. Tinson for his partnership on this symposium and his leadership in creating a really important department. One of my own academic homes. I have a PhD in sociology and African American studies, so thank you for all of your work. And last but not least, I want to thank my friend and colleague, Dean Bill Johnson, for extending me the honor of giving the 2021 Dean Richard J. Childress Memorial Lecture. So earlier this year, Dean Johnson contacted me to ask me to give the Childress Lecture, and he made a point of stressing the importance of the lecture to me, asserting that Dean Childress, who served as SLU's dean from 1969 to 1976, was, quote, something of a giant at SLU, given his commitment to justice, among other things. And having read just a little about Dean Childress, his life and his work, I must say that giving this lecture is an immense point of pride and distinction for me. As many of you know, Dean Childress came to St. Louis School of Law as a faculty member with a long, distinguished record as a lawyer and as an advocate for civil rights, for equality and dignity for all. In fact, in an article entitled "Why the Childress Lecture" in 2008, SLU alumnus Malcolm J. Harkins detailed Dean Childress's truly impressive background as a social justice warrior, noting that Dean Childress was a public voice for fair housing, equal employment rights, and equal access to places of public accommodation during the 1950s. That Dean Childress took on more than his share of cases, serving as appointed counsel for no compensation for individuals who were charged with crimes. That Dean Childress served as the director of the St. Louis Urban League for 10 years, was a member of the St. Louis Conference on Religion and Race, and was twice the chairman of the St. Louis Archdiocese Commission on Human Rights. And importantly, that Dean Childress bravely marched with Dr. Martin Luther King, a man whom we are proud to note is a Boston University alumnus, from Selma, Alabama to Montgomery, Alabama, in that fated historic trek that we know resulted in Bloody Sunday. Mr. Harkins described Dean Childress as a man who was, quote, never afraid to stand on the side of right, and as a man who transformed St. Louis University School of Law by greatly increasing the percentage of women students and students of color. Harkins described Dean Childress as a person who was always ahead of the curve, as a leader who helped to transform legal education by helping to create clinical education at a time when very few other schools offered any clinical education. And to give us a sense of who Dean Childress was, Mr. Harkin pointed out that in Dean Childress's address to the last graduating class before he passed away, he told them that, quote, the practice of law was not just about representing clients, it was about affecting society and causing society to address its problems in a way that benefited all, but especially those who have no voice. So it's no surprise that your community annually honors this giant, Dean Childress, with this lecture and symposium. And I'm delighted to be a part of that celebration and that honoring of him. And I also have no doubt that many alumni and friends will continue to endow more in his name, and actually hope that more people will do so. It's such a great record. And I want to say a couple more things. In many ways, I'd say Dean Johnson reminds me of what I've come to know about Dean Childress. From afar, I've watched Dean Bill Johnson follow in his very big footsteps. Like Dean Childress, Dean Johnson is kind and gentle and committed. It's a quote from the paper I read. He likes people above all else, and he too is, quote, delighted in working with them and helping them solve their problems. He also exhibits a deep commitment to social justice and racial justice. Indeed, when he wrote to extend this invitation to me, he informed me, quote, the topic this year will be critical race theory and the law, in part to shine a spotlight on the importance and value of CRT as it has come under attack, even as we approach nearly 50 years since Derek Bell's seminal text, Race, Racism, and American Law. So I want to note that the decision to make critical race theory this year's topic for the Childress Lecture and Symposium is not one that we should overlook. In a context in which a full-scale attack has been launched against critical race theory to undermine and discredit the field as divisive, and as my co-editors and I point out in our forthcoming book, Critical Race Judgments, as being beyond all reason, the decision to identify critical race theory as this year's symposium topic merits our applause and admiration. It's a courageous move for a law dean, for an associate dean, for law school journal editors, at a time when simply talking about race or educating students about our nation's true racial history can result in accusations about one's being un-American, about one being divisive. It wasn't long ago the term critical race theory was virtually unknown outside of academia. In June 2020, Fox News mentioned critical race theory 3 whole times. But a year later, by June 2021, the very same news outlet had mentioned critical race theory more than 900 times. In essence, critical race theory has become a political lightning rod. In fact, this summer, Citizens for Renewing America, an advocacy organization founded by a former Trump administration official, released an A to Z guide on how to stop critical race theory in your community and how to reclaim your local school board. And the guide mischaracterizes critical race theory as a radical theology that will socially replace, using quotes, socially replace white people. To advance their cause, organizations like Citizens for Renewing America and their adherents are using the same old playbook of mobilizing followers by stoking fear. So for example, consider this quote from the guide, which proclaims that critical race theory scholars contend that, quote, straight white people, children included, are inherently and irredeemably racist and benefit from, as well as systemically rig, all the social institutions, rules, and laws and norms that white people invented and keep in place for their own disproportionate success and in order to maintain their own stranglehold on power. Unfortunately, efforts by groups like these are gaining steam. During the first half of this year, 126 recall initiatives were launched against school board members, more than any other group of elected officials. Additionally, more than half of the states in our nation have introduced bills or have taken steps to restrict teachers from discussing racism, not simply critical race theory, but racism in the classroom. And a dozen have already enacted laws to that effect. So before I begin my lecture, it makes sense for us to recognize Dean Johnson, Professor Chad Flanders, Dylan Ashdown, and the St. Louis Law Journal editors for taking a courageous step in publicly acknowledging critical race theory as worthy of discussion, as worthy of being the subject of this esteemed symposium and lecture. So thank you. So with all that said, I wanna now engage you on my belief that CRT, or at least its principles, stand at the center of most of the prominent social movements that we see today, from the resurgence of the #MeToo movement, which was founded by a Black woman, Tarana Burke, to the Black Lives Matter movement, which was founded by 3 Black women, Opal Tometi, Alicia Garza, and Patrisse Cullors, to the Say Your Name, Her Name movement, founded by none other than Professor Kimberly Crenshaw, the woman who coined the term critical race theory, and the woman who developed the concept of intersectionality, created and developed the concept of intersectionality. In fact, critical race theorists have long defined CRT itself as a movement, as a scholarly movement, one that has not only provided theoretical interventions regarding the relationship between race, racism, and the law, but that has also encouraged and in fact inspired and guided action in social movements. The summer of protests in 2020 even offer some insights. The murder of George Floyd by former officer Derek Chauvin in Minneapolis ignited large protests across the globe, led by millennials mostly, who are the second most racially and ethnically diverse generation in the history of the United States, second only to the next generation, Generation Z, who were also very much a part of those protests. The summer 2020 protest had, as the Los Angeles Times described, created a multicultural movement that made history. As my Boston University School of Law colleague, Professor Karen Peter-Lore has taught us, the summer 2020 protests were also our largest protests, with the flood of people who demanded racial justice surpassing the numbers of protesters in the civil rights movement of the 1950s and 60s. For example, in just one day in June, approximately 500,000 people gathered in protests in 550 sites across the United States. And of course, that's not even counting all the people that we saw in protests that exploded around the world. Looking back at the protests of 2020, we can see that the leaders of the current social movement for racial equality drew some of their strategies and tactics from the playbook of the civil rights movement in the 1950s and 60s. Still, as many have proclaimed, those protests also felt different. Not only were the protests a rainbow coalition of races and economic groups, the most racially diverse, right, protests, they also achieved reforms that had once seemed unimaginable. And many scholars have asked why. What forces enabled these protests and outcomes to take effect? And in my lecture, I argue that two major factors can help to explain the successes of these more recent protests, like #MeToo and #Black Lives Matter. First is the emergence of critical race theory, specifically the insights that millennials and Generation Zers have gained in college classrooms across the nation, insights that have not only given them a language and expectation for what they should expect and demand to achieve equality, but also the theoretical frameworks for establishing and building the movements and solutions to achieve that vision. And second is the emergence of social media and its impact on the resource mobilization component of social movement making. So in making this argument, I will first discuss how CRT has played a meaningful role, where we see CRT in the Black Lives Matter movement and shaping ideas behind that movement. And thereafter, I'll briefly highlight classical sociological models concerning the how of social movement theory, meaning the informal and formal means to which people form social movements. And then I'll explain how the emergence of social media has helped to create new avenues of communication, outreach, and movement making for those who did not previously have access to power and traditional media networks to mobilize their own social movements. So if we look at just a few of the most prominent social movements of our time, we can see how CRT, our ideas, principles from CRT, are actually laced throughout these movements. So for example, consider Black Lives Matter along with the related Say Her Name movement. The Black Lives Matter movement emerged out of the tragedy of Trayvon Martin's death in Sanford, Florida in 2012. On February 26, 2012, George Zimmerman, a man of white American and Peruvian descent, shot and killed a newly turned 17-year-old African-American male named Trayvon Martin. After getting candy and refreshments from a local 7-Eleven, Trayvon Martin was walking back to the house of his father's girlfriend, Brandy Green, in a gated community called the Retreat at Twin Lakes in Sanford, Florida. And when the teenager was shot and killed by George Zimmerman, the teenager famously had nothing on his person but an Arizona watermelon drink, a bag of Skittles, and the cell phone he'd used to speak to his friend, Rachel John Tall, shortly before he was killed. Although Zimmerman shot and killed an unarmed teenager that night, Sanford police released him that very night because he asserted a claim of self-defense, and they found no evidence that evening to contradict his claims. In fact, Zimmerman would not be charged with any crime at all until April 11th, 2012, almost a month and a half after he had killed Trayvon Martin. That charge of second-degree murder by prosecutor Angela Corey came only after weeks of a brilliant social media campaign ignited by Benjamin Crump, the attorney for Martin's mother, Sabrina Fulton, and his father, Tracy Martin. At trial, Sanford prosecutors would do such a poor job presenting their case against Zimmerman that noted defense attorney Mark Garrigo speculated that the attorneys purposely threw the case. Ultimately, on July 13th, 2013, an all-female and nearly all-white jury acquitted Zimmerman of both second-degree murder and manslaughter for Trayvon Martin's death. Saddened by this outcome and upset that Trayvon Martin had been posthumously put on trial, Alicia Garza penned a letter on Facebook to explain why the anger that so many African Americans felt was justified and to simply proclaim that, quote, Black Lives Matter. Seeing Garza's post, an inspired Coolors created the hashtag Black Lives Matter and began posting it on social media. Fresh from the movie theater where she had just viewed a movie about the shooting death of Oscar Grant by a Bay Area policeman at the Fruitvale BART station when he was handcuffed and laying face down on the ground, Tameti contacted both Garza and Coolors to discuss how three women could create a platform that would communicate the message that Black Lives Matter. Tameti asserted, quote, I remember in that moment, just sitting with the fact that everybody knew what took place, and despite all the knowledge, despite the testimonies, despite all of that, Trayvon Martin was put on trial for his own death. I was struck with the fact that my young brother, who was 14 at the time, could have been Trayvon. I thought we need to have other people interact with this message and also share the work that they're doing to ensure Black Lives Matter. When Michael Brown was then killed a little bit more than a year later, on August 10th, 2014, the Black Lives Matter movement founded by these three Black women gained significant traction. According to Garza, Tameti, and Coolors, Black Lives Matter is an ideological and political intervention in a world where Black lives are systemically and intentionally targeted for demise. That's a quote from them. The movement was created specifically to highlight how Black people are routinely deprived of basic human rights and dignity and encounter deadly resistance to mere existence and create a space for the celebration and humanization of Black lives. So if you look at the action of Black Lives Matter, it's deeply rooted in some of the core tenets and principles of critical race theory, and I'll name them before I talk about some of the examples. Some of these principles include the understanding that race and our understandings of race is socially constructed and that racism is not aberrational. Racism is usually something that happens every day in this country. Second, that colorblindness is not a pathway to ending racial subordination because pretending racism exists is not the same as creating equality. And because racism involves more than just stereotypes and individual prejudice, it also involves structural racism. And so destructive policies and institutional practices also have to be dismantled. Three, that groups are racialized differently. While the forms of racism that different groups encounter may be similar in some contexts, each group's experiences its own unique form of racial subordination and oppression. Four, racial subordination of Black people serves both psychic and material purposes for whites. Five, people of color bring a unique voice to discussions and solutions concerning racism precisely because of their experience as racialized people, historically and currently. Six, interest convergence is how change occurs. As the late Derek Bell explained, in the United States and elsewhere, gains for people of color tend to come only when those interests of people of color converge with those of the decision-making elite. Seven, that tools such as storytelling and narrative are effective means of reaching a wider audience in part because of their accessibility. And eight, finally, there's no essential identity for any group and that people's identities cannot be separated. There must be an intersectional analysis. So at its core, Black Lives Matter centers on the notion that our understanding of race and race people are socially constructed, that different groups are racialized in different ways, that colorblind approaches are not effective means for dismantling subordination, and relatedly, that constructing strategies based on converging interests is not the way to quote unquote get free, as Professor Paul Butler would say, and that stories matter. I'll give you a couple examples in a second. For instance, rather than organizing under a race-neutral moniker or a moniker that referred to all people of color, the founders, Alicia Garza, Opal Tometi, and Patrisse Cullors, opted to embrace rhetoric that speaks to the disparate treatment that is felt specifically and uniquely by Black people in the United States. And in so doing, these three women have pinpointed the similar but unique history of genocide and oppression of Black people, including the unique existence and practice of slavery, which rested upon and conveyed a message of Black people as subhuman, less valued, and unworthy of life, a message that, though repudiated in explicitly written laws of today, continues to carry great force in society. The movement communicates the reality that Black lives in particular are framed as dangerous and deviant in ways that lead officers and civilians alike to quickly link Blackness to criminality, as well as more quickly view an inanimate object in a Black person's hand as a gun, or see a Black person's actions as hostile and thus deserving of excessive force, such as shooting and killing. And there are lots of implicit bias studies that reveal this. In addition to focusing on the unique ways in which Black people are racialized and discriminated against, Black Lives Matter also has embraced the anti-colorblind principle in critical race theory. The Black Lives Matter movement's endorsement of an anti-colorblind approach is most evident in its response to resistors who insist on asserting that all lives matter. Through protests and interruptions at events like gatherings for presidential candidates, Black Lives Matter protesters have educated the public about the damaging effects of pretending that all individuals, regardless of race, face the same hostilities. As Garza once explained, quote, "We perpetuate a level of white supremacist domination by reproducing a tired trope that we are all the same, rather than acknowledging that non-Black people benefit from anti-Black racism. When you drop Black from the equation of whose lives matter and then fail to acknowledge it came from somewhere, you further a legacy of erasing Black lives and Black contributions from our movement legacy." At the same time, Garza, Coulors, and Tometi have made clear that the statement that Black Lives Matter does not mean that Black lives are more important than other lives, or that other groups do not face criminalization or oppression. Just that there must be a focus on the particularized means of state violence against Black people. They note, quote, "We remain in active solidarity with all oppressed people who are fighting for their liberation, and we know that our destinies are intertwined," end quote. Furthermore, Black Lives Matter insistence that voices of color not be silenced or subdued or hidden by the voices of allies rest upon the notion of a unique voice of color, in this case, a unique voice of Blacks. The movement welcomes allies of all races, but expresses a need for those allies to investigate and examine how anti-Black racism is perpetuated, furthered, and emboldened within their individual communities. Additionally, the movement represents a very interesting example of interest convergence in social activism. Rhetorically, Black Lives Matter refutes interest convergence as a means of achieving progress. In fact, as I noted before, Black Lives Matter calls upon members of the dominant group to enhance the lives of Black citizens for no other reason than because Black citizens matter too, or Black people, not necessarily citizens, matter too. There's no focus on reframing the argument that Black Lives Matter in a way that could appeal best to others. On its face, Black Lives Matter does not appeal to the interests of the majority. However, the movement, certainly aware of the power of interest convergence, has articulated how ensuring that Black lives are equally valued can be a benefit to all people, not just Black people. One of the mantras of Black Lives Matter is that when, quote, Black people are free, everybody gets free. The argument goes, quote, hashtag Black Lives Matter doesn't mean your life isn't important. It means that Black lives, which are seen as without value within white supremacy, are important to your liberation. Given the disproportionate impact state violence has on Black lives, we understand that when Black people in this country get free, the benefits will be wide-reaching and transformative for society as a whole. When we are able to end hypercriminalization and sexualization of Black people and end the poverty, control, and surveillance of Black people, every single person in this world has a better shot at getting and staying free. And some, even though the movement has rejected interest convergence as a means of accomplishing their legislative agenda, by refusing to reframe its arguments in ways that could diminish the focus on Black lives, it has also embraced interest convergence, this notion that the gains for people of color occur only when their interests converge with those of the decision-making elite. They've done this as a means of conveying how the equality of all of Black people can enable equality for all. So furthermore, their projects like the project I Imagine have incorporated the strengths of storytelling that critical race theorists have been touting since the beginning. The I Imagine project asks people to submit audio responses of their visions of what life would look like in a world where Black lives matter. By relying upon personal narratives and audio clips of real people, Black Lives Matter has engaged in the project of rewriting stock narratives, what Richard Delgado calls stock narratives of the Black experience, and has instead offered what he calls counter stories, countering stereotypes through personal storytelling. Counter narratives are critical because they are one of the ways that implicit and explicit biases can be reduced. Indeed, Black Lives Matter has explicitly stated, art is key in helping us imagine a new vision for the world. And these types of retellings have become a staple of Black Twitter, which one could argue is an extension of the Black Lives Matter movement. So over and over, Black Twitter has highlighted the privilege rooted in the different treatments of Black and white victims. So consider the example of a Twitter campaign, If They Gun Me Down, and it's the first slide. This Twitter campaign offered a sharp and persuasive critique of the ways in which Black victims get demonized in the media through chosen representations of their character. In this critique, Black tweeters posted two contrasting pictures of themselves, suggesting within their posting that the more sympathetic photograph, often from a graduation, a military ceremony, or church scene, would be the photograph that the media would choose to ignore, instead choosing to publish a more racially stereotypical or negative image, an image that provided only one limited snapshot of their lives. Last but not least, we see critical race theory in action with a stance against essentialism and endorsement of an intersectional approach. The movement rejects the notion that there is one unitary Black identity. It openly and directly challenges the ways in which past social movements have treated Black, heterosexual, cis, male, Christian identity as representative of all Black experience. Black Lives Matter rejects the idea that an individual's identity can be divided into parts and discusses the importance of how African Americans experience life at the intersection of identity categories. Founded by 3 Black women, 2 of whom are queer identifying, the Black Lives Matter movement works to affirm all Black lives, regardless of gender identity, sexual orientation, immigrant status, sex, color, religion, and so on. The movement's guideline principles include prioritizing intergenerational approaches to organization and alternative family structures. The founders, for example, proclaim, quote, Black Lives Matter affirms the lives of Black queer and trans folks, disabled folks, Black undocumented folks, folks with records, women in all Black lives along this gender spectrum. It centers those that have been marginalized within the liberation movement. It is a tactic to rebuild the Black liberation movement. So that said, the actual success of this intersectional approach has been called into question by other movements like the Say Her Name movement, which in a sense is claiming that this movement, the Black Lives Matter movement, has focused too much of its organizing on male victims of police brutality and has neglected female, transgender, or gender non-conforming victims. Say Her Name advocates an expressly intersectional approach to anti-police violence, racial justice. It provides that the rhetoric and organizing concerning victims of police brutality have centered on the narrative of male victims. And it has created a counter narrative of racialized police violence. It asks those interested in social justice to not just generally say the name of female victims of racialized police violence, but to understand their lives and what their deaths mean. The Say Her Name movement also advances the critical race theory tenet that racism is not an aberration, and in particular, that non-male Black deaths at the hands of police officers are not an aberration. That they are, in fact, quite the norm. By asking people to say her name and thus consider the female, transgender, and gender non-conforming victims of police violence, it advances a CRT principle of racism, not as a deviation, right? The more we say her name, the more we understand the unfortunate consistency at which these deaths too occur. Now to the theory about social movement making. So one of the reasons why Black Lives Matter and Say Her Name have grown and developed as strong burgeoning movements is the shift in social movement making that has occurred as a result of the social media's influence. Such that social media movement leaders do not need to rely as heavily on traditional media gatekeepers, right? In fact, I contend that the social media has altered the making of social movements such that social movement leaders do not need to rely on these networks like CNN, ABC, CBS, MSNBC, and so on, much like past civil rights leaders previously had to do to attract the attention to their causes. It's not that these traditional gatekeepers are no longer important. It's just that the right tweet or Instagram or Facebook post in today's society can go viral in ways that force these traditional media gatekeepers to follow social movement leaders in finding new stories, rather than the movements having to chase down these networks, these magazines or newspapers. And previously, there was no way to do that. So traditional models of social movement theory have focused on movements as products of grievances or social strain. And these models have primarily proposed a psychological process where social conditions have affected individuals and motivated them to challenge the status quo. As sociologist Matthew Huey has explained, early scholarship on social movements posited that, quote, social movements were emotionally charged, unorganized, spontaneous, and disruptive behavior incongruent with institutional or organizational order, end quote. More recent social movement theory, however, is centered on three theoretical perspectives: mobilizing structures, political opportunities, and framing. And these approaches form what one might call the how, the where, and why of social movement theory. The first approach or paradigm, mobilizing structures theory, addresses the how of social movements. It looks at informal and formal vehicles through which individuals may form social movements. And within this theoretical framework, there are two branches. The first branch is the resource mobilization theory, which has garnered the most scholarly attention. And here's where I'm focusing my energies. Research mobilization theory focuses on the role of formal organizations in developing social movements. In other words, it centers on the formation of social movements by professional organizations. And the second branch of mobilizing structures, the political process model, focuses on informal grassroots mobilizing structures, like the role of Black churches in the civil rights movement. Looking at mobilizing structures theories, we can see that social movements have never really been spontaneous or unorganized. Often they're carriers of the narratives of the movement who are framing the issues and helping to push these particular narratives along. Take, for example, the different ways in which media and social media helped to launch the movements around the deaths of Emmett Till in 1955, Trayvon Martin in 2012, and Michael Brown in 2014. In 1955, Mamie Till Bradley, the mother of Emmett Till, views the lynch body of her son, and she bravely makes a decision to say, I want everyone to see the ugliness of racism. She decides she wants to have an open casket funeral. She decides that she wants the pictures of her son's mutilated face and body to be published in magazines, Black-owned, Black-published magazines at the time, Jet magazine. And by doing that, and by having access to those media gatekeepers, she's able to ignite a national, international movement, because people were able to personally witness the atrocities that were committed against Blacks in the South, right? So over that period of the open casket funeral, the open casket wake, more than 100,000 people walked past Emmett Till's mutilated face in 1955 in Chicago. Millions more view the photographs of his face all over the world. If you want to Google it, you can see it. It's horrific, and I won't show it to you. And a number of scholars have talked about how that gave a face to the ugliness of racial violence and oppression in the South, particularly to Northerners, including Black Northerners, who had not been forced to confront on a consistent basis. And in particular, in the case of some whites at all, not confronted it at all. Much like one could say the videos that we see today do for people today. In the end, Till Mobley's use of the media to expose and educate resulted in this burgeoning civil rights movement that would take off, especially a few months later, when Rosa Parks refuses to give up her seat on a bus in Montgomery, Alabama. And in fact, we know that Rosa Parks once identified Till as a source of her inspiration on that day, saying, quote, I thought of Emmett Till When the bus driver ordered me to move to the back, I just couldn't move. We see similar tactics employed in more employed in movements that employed in more recent movements, and particularly we saw it employed by Benjamin Crump quite wisely, and after the slaying of Trayvon Martin. In fact, after Trayvon Martin is killed, his parents go to Benjamin Crump to get him to represent them, and he's like, "No, I'm not going to represent you. You don't need me. This is such an easy case. You won't need me." But a couple weeks later, they still aren't able to get attention a few days, several days later on the case. And so he decides to take the case. It fails to get media attention, and he decides he's going to follow basically in the steps of Mamie Till Mobley and enlists the help of the media. He holds press conferences in the local media in Florida. He organizes several rallies to call for justice for Trayvon Martin. He enlists the help of Reverend Al Sharpton. And in fact, they begin to build so much of an audience for the cause that even the church of Pastor Ronald Durham, which held several hundred people, was not big enough to contain the participants of this first large star-studded rally demanding justice for Trayvon. And in fact, we first begin to see the significant reach of his work there. There are people from locations as far as Hawaii, Australia, the United Kingdom, and France who traveled to Florida to participate in that particular rally. There are rallies occurring in cities in New York, in Washington, D.C., and Los Angeles at this time. The first national news report on Trayvon Martin's death occurs on March 8th, 2012 with CBS News. It's about 2 weeks after his death. And from there, news coverage explodes. Much like in the Till case, where the Black press brought Till Mobley's grief and story into American homes, the Black press was critical to the emergence of Martin's death as a top story in the country. Black journalists like MSNBC's Melissa Harris Perry, CNN's Don Lemon, the Griot and MSNBC's Joyanne Reed, the Washington Post, Jonathan Capehart, and New York Times, Charles Blow, all worked hard to keep the story in front of print and television news media. An additional factor in the explosion of the media coverage was the release of the 911 tapes on March 16th, 2012, a little bit more than a month after a little bit less than a month after the killing. So seeing the importance, Benjamin Crump noticed the importance of the release of these tapes, and he puts pressure on local government officials to release the tapes. And when the tapes are released, particularly the 911 call of George Zimmerman's call to 911, and the Lauer 911 tape, which featured high-pitched screams for help from either Trayvon Martin or George Zimmerman, that then get a large amount of national and international presence. And it's at this point that we see the impact of social media. When the 911 tapes are released, the tweets about Trayvon Martin become so numerous, if you do analysis, and unmanageable to count. Almost overnight, the number of tweets made on March 16th and March 17th surpassed the amount of tweets made in the entire previous 3-week period after his death. And almost all of those tweets are about the 911 tapes. Another impact we see in social media is we see Black lawyer Kevin Cunningham use a petition on change.org called Prosecute the Killer of Our Son, 17-year-old Trayvon Martin, to launch a petition to put some pressure on local government officials. And there's stars who come in. John Legend, Spike Lee, Mia Farrow, Cher all helped to publicize the petition, encouraging their fans to sign it. By March 26, 2012, with the help of an organization named Million Hoodies Movement for Justice, the petition collected a record-breaking 2 million signatures in less than 3 weeks' time. And with the help of stars like Rihanna, Miley Cyrus, will.i.am, hashtags like #Trayvon and Justice for Trayvon were trending, meaning they were among the top 10 topics that Twitter's 500 million plus users were following. On March 12, 2012, the Sanford police chief holds a press conference to explain his department's inaction. He indicated the police did not have probable cause to arrest, and he claimed that George Zimmerman acted in self-defense, and there was no evidence to the contrary. On March 22nd, that same police chief is placed on paid leave. And the day before, there were hundreds of people that were marching the street in New York City for the Million Hoodie March. We also see other stars using social media to create an impact. I'll show a couple more, and regular people. I'll show a couple more slides. I'm almost there. On March 23rd, 2012, the interracial group of players from the Miami Heat basketball team posted a picture of themselves wearing hooded sweatshirts in support of Trayvon Martin and his parents. Black fathers, individual Heat players like Dwayne Wade and LeBron James each tweeted about the killing. And so, for example, LeBron James, while posting a picture of the team, tweeted all these things. We are Trayvon Martin, hashtag hoodies, hashtag stereotype, hashtag we want justice. On March 23rd, Governor Rick Scott appoints Angela Corey as special prosecutor, asking her to review the evidence and to make an independent determination. And then finally, on March 23rd, also, we finally hear from President Obama, who breaks his silence. And he says, obviously, this is a tragedy. I can only imagine what these parents are going through. And when I think about this boy, I think about my own kids. I think every parent in America should be able to understand why it is absolutely imperative that we investigate every aspect of this, and that everybody pulls together, federal, state, and local, to figure out exactly how this tragedy happened. I think all of us have to do some soul searching to figure out how does something like this happen. And that means examine the laws and the context for what happened, as well as the specifics of the incident. But my main message is to the parents of Trayvon Martin. If I had a son, he'd look like Trayvon. And I think they're right to expect that all of us as Americans are going to take this with the seriousness it deserves, and that we're going to get to the bottom of exactly what happened. Next picture. Soon after that, we have another picture that goes viral from a white mother, regular citizen Erica Verba, and other white female mothers begin to post pictures of themselves and their children wearing hoodies to show solidarity with Trayvon Martin. These start to go viral on Facebook. She also writes a powerful letter. And she puts, as a white mother of a white son, I do not pretend to know what you must be going through right now. I respect and honor my differences. My neighbors and I have taken these pictures because we want you to know that you are not alone. We have all wept for your son. We dress our children in hoodies because we want them to grow up to share the burden we feel. We want them to know that if a child or a group of children are not safe in this world, then we are all responsible. We want them to know that today, at this moment, we are all Trayvon. May God bless you and bring you comfort. Then we have celebrities, last photo, people like Muhammad Ali. And I put this because Muhammad Ali, you don't know this one, Muhammad Ali talks really quite eloquently about the impact of hearing about the death of Emmett Till on him when he was a kid. And so just given the many comparisons of this, it's really powerful when he posts this particular picture. And there are a number of other people who do it. Avril Lavigne, Bill Cosby, well, Selena Gomez, I drew this list of Selena Gomez, Zac Efron, Marion Wright Edelman, former Michigan Governor Jennifer Granholm, Rihanna, all donned hoodies. Bobby Rush makes an empowered speech before the US House of Representatives. And then finally, on April 11th, 2012, Angela Corey charges Georgia Moon with a crime. Right, so the use of social media here demonstrates, and I'll tell you why, how we can tell that there's a difference to the American public, how activity on social media venues like Twitter and Facebook could direct and guide the national news media in selecting and developing its own news stories. After the Trayvon Martin killing and the social media movement that ultimately led to the charges against Zimmerman, the organization Million Hoodies Movement for Justice and other movements have taken steps to remain ahead of the story. Its members have kept track of these stories. They want to push stories and articulate counter narratives to damaging racial narratives with a tool the organization calls #OccupyMap. Members log and publicize incidents of police misconduct and other forms of discrimination in ways that help these incidents get more traction in national news media. And one of the most powerful examples actually comes from right here in Missouri. It comes from the coverage of the shooting of an unarmed Black 18-year-old named Michael Brown by former police officer Darren Wilson in Ferguson in August of 2014. And you see it's almost an immediate impact. Well, the killing of Trayvon Martin did not become the subject of national television news story until March 8th, 2012, right? A full 2 weeks after his death, and was not addressed by President Barack Obama until a month later, on March 23rd, 2012. Michael Brown's killing was reported by nearly every major national news television channel the day after it occurred on August 10th, 2014. The death occurred on August 9th, Everybody's reporting about it on August 10th. In a matter of hours, Michael Brown's story, which is one of the stories they were pushing, had many more tweets than the Trayvon Martin case did in its first days. Trayvon's case took weeks to gain traction, and on the other hand, it took really a couple of hours. Within hours on Twitter, you see that Michael Brown's case is gaining traction. More so by August 14th, we're talking about less than a week after the shooting, we have the president addressing the nation about the country needing a time for healing after the Michael Brown case. So what social media movements like the one concerning the killing of Michael Brown reveal is how social media has given everyday people a critical tool for creating their own news, making it more of a norm rather than the exception. Of course, still these media gatekeepers are important, they still need to run the story. Before social media began to shift social movement making, what made the Emmett Till and Trayvon Martin deaths exceptional was not the fact that deaths occurred, because far too many young Black boys have been killed by police and quasi-police officers, but instead that the deaths had received significant media attention, and in fact that they had been endorsed by and embraced by traditional gatekeepers and made news by those gatekeepers. Today, however, individuals, families, organizations do not necessarily need the national media to first endorse a story like maybe Till Mobley needed the press to do so during 1950s, or even Trayvon Martin's parents needed in 2012. Now there's less need to figure out specific ways to obtain an opening endorsement of traditional media gatekeepers, because stories can go viral or get spread on Facebook or Instagram or other social media outlets without any push from the national media. In fact, in increasingly more instances, the national news media is following the lead of social media and picking the stories that it covers. And despite the fact that so little has changed in terms of the power of certain tropes and narratives over the past 60 years, movement leaders today find themselves at a moment where grassroots public campaigns or professional social movements on social media might actually lead to successful change, particularly when those narratives are married to themes from critical race theory. And perhaps one might say that it is #CRT, this hashtag, that has helped to bring us closer to make sure that we see some of the meaningful changes that we see today. Thank you.
Time to take one or two questions.
Yeah.
And if you're online, you can type it in the Q&A function. Can I just ask, does polarization sort of blunt the force or limit the
Yes.
force of social movements? Because
Yes.
we're just tweeting to one another.
Yes.
Is there a ceiling there?
Yeah, I think that absolutely does, right? So there's a balkanization, obviously, and there's been a lot of news about that too, right? So it's not that the movement, the tweeting allows more people to get the movement, but what it does is it draws the attention of the traditional gatekeepers so that they're then following the stories rather than the ones creating the stories. So in the 1950s, or even you could say even in 2012, it was really that the traditional media gatekeeper, the CNNs, right, of the world, right, had to say, we think this is a story worth covering, and so we're going to cover it, and therefore it's going to do it. But now, if something catches fire on social media, CNN kind of almost has to cover it, right? Whether or not they would have done so to begin with, and that's part of the argument. That's the argument, essentially.
Oh, we got a long question on the chat, but
Okay,
do you want to?
sure.
I'll just read. You describe convergence theories predicting success when Black interests converge with those of white elites, but does that criticism apply to anti-racist, multiracial convergence, such as the Sanders campaign? Opinions seem to diverge. Taylor was a huge Sanders supporter. Others criticize this.
I'm not sure.
I'm not sure yet. So it's.
I'm trying to understand the question. If you could write more, I could understand the question.
So if you
So,
want to clarify.
so it's less the elite part is. I mean, the thing about the elite is about who's making the decisions, who's in power. So, and it's generally the argument is about who's. So the elite's usually about formal decision makers, like, so who are the people, is it the Supreme Court, is it the legislators, or whoever's school board, whatever it is. And the argument is just that the only time you'll see the rights of traditionally marginalized people being recognized is when it also happens to work for those who also happen to be in the dominant group, right? And so I'm not sure it works in the context in which they're talking about. They can write more. So
we got a question about the intersection of class and race. And so could you just, it's sort of a general question about the intersection of critical race theory with issues of class. That's sort of the general question.
yeah, well, so those things are always overlapping. I mean, I think that one of the key core tenets of critical race theory is that, you know, is that we don't just intersect, we just don't live in one particular box, right? That all aspects of our identity are intersecting. But I think also in this country that you often find that those things are, that race and class are often intersecting because of the particular history of discrimination. And we're talking about particularly with Black people and the history of enslavement and all the various ways in which particular laws and practices have played out so that Black people have been excluded from particular ways in which people have built wealth in this country, whether it is limited access to the GI Bill, no access to the land that was given to people through the Homestead Act, you know, exclusion from the Social Security Act through exclusion from excluding people who are domestic workers and agricultural workers, right? Redlining, which prevented people from, building wealth in the ways through their homes, which is the way most people build wealth, and then being able to pass it down from generation to generation. I mean, discrimination on the job market, those things overlap because of the way discrimination functions in this country. But we all also experience life at the intersection of our various categories, right? It's a key concept, intersectionality of critical race theory.
Thank you again for being here. So I have a question. I'd like to ask you to engage in an active imagination.
Pardon?
I'd like to ask you to engage in an active imagination.
Sure.
So imagine that we're not in the world that we wish we were in, but we're headed in that direction. So you've described for us this interplay between critical race theory and what a body of ideas that started in legal scholarship and social movements. So imagine that there's another tragedy and there's another trending hashtag on Twitter. What in your imagination would be the best response of lawyers to the next tragedy? Lawyers in our community, our law students, ourselves.
So what's the best response of lawyers and law students to the next tragedy? I mean, I think that some of them you see already that people are organizing, people like Justin Hansford, who were here, other people who were, who's a professor here at SLU, were already organizing lawyers to do some of that work, which was to help to represent protesters who were arrested, including people who were arrested. I think like he was one person, people who was just arrested for standing, basically. I think always you want lawyers to be thinking deeply about how to engage in broad impact litigation that helps to change the very structures, because doing the things that only help to stop bleeding for one individual, right? It doesn't mean that it won't keep repeating itself, right? But it's really getting at the actual, whether it's, people might disagree about whether it's bad law or not, but getting at the law that allows for sort of the hyper policing of certain communities, like, things like, making it so that what gets defined as a bad neighborhood, thinking about a particular case that was decided in Massachusetts where our Supreme Judicial Court, I think, quite rightly decided that it's not evidence of guilt. Running away when you see a police officer on its own isn't evidence of guilt. That taken into the context that if you're an African-American man, or young boy who run away from the police, it doesn't mean that you're guilty. It might mean that you're just literally scared for your life, right? And that there would need to be other things other than that alone, right? So I think bringing the kinds of cases that might challenge bad law that allow for particular things to happen over and over again is something that I would think about. So funding, lots of funding. So people who have resources, very, very important for people who have resources to fund both people who are out doing protesting and engaged in social movements, and also the fund litigation so that people can be bringing these kinds of cases that both challenge both sort of hyper policing, that challenge racial profiling, and all other things. I mean, that's what I would say, is what lawyers should do. But I think that many people are already doing some of the things I would hope that lawyers are doing. They just need more resources to do it, I would say. Fund a clinic I'll say this to Dean Johnson, and you can do it at BU too, but fund a clinic at BU and a SLU that allow students to engage in this work.
All right, so we should probably move on, but let's thank you once more. Thank you so much. All right, let's get started. So my name is Chad Flanders. I am not Belinda Dantley. She unfortunately couldn't be here today, so I'm stepping in. So our first panel is on perspectives on critical race theory. And we have three fantastic panelists. The first is Danielle Conway. She's the Dean and Donald J. Farage Professor of Law at Penn State Dickinson Law School. She'll speak first. After that, it'll be Mario Barnes, the Tony Remby Dean and Professor of Law at the University of Washington Law School. And finally, it will be Christopher Tinson, whom you've met, the Associate Professor and the Chair of the African American Studies Department at St. Louis University. Danielle Conway, Dean Conway, will be joining us through Zoom, and she will start.
Thank you so much. Is it okay to get started now?
Yes.
Terrific. I want to echo the thanks and the acknowledgement that the Childress Lecture is taking a bold and courageous stance to address the topic of critical race theory. And I want to congratulate my colleague, Dean Angela Onwuachi-Willig, for constantly educating us about important issues that impact racial justice. So I will get right to it. The talk that I am going to give is titled "The Assault on Critical Race Theory as Pretext for Populist Backlash on Higher Education." And I want to start positively by saying what makes higher education institutions democratic is the commitment to teaching and learning that centers critical thinking and the capacity to reason and engage peacefully in the face of difference, disagreement, and dissent. Higher education institutions offer place and space and resources to practice the indicia of democracy. These indicia include freedom of thought and speech, equality among peoples and perspectives, the building of the muscle of resistance and contestation, the courage and capacity to question the dominant policies, procedures, practices that impact people differently, and the commitment to making what seems impossible, universal humanism, based on unfettered equality, possible. Higher education institutions are vital to democracy because they have as a core feature the power to convene large swaths of people who have important, enlightened ideas to generate, grow, and disseminate knowledge that can be used to strengthen democratic institutions. The significance of higher education institutions as places where democratic ideals can be practiced routinely is exactly what makes them targets for populist backlash. Universities have been one of the main focal points of attacks by far-right leaders. The tactics for targeting higher education institutions involve a unification of patriarchy with an allegiance to a national identity, both combining to hold power for the purpose of precluding critiques of America's long and violent history with individual and institutional racism. The threat of disinformation and misinformation about America's history and promoting and exploiting human bondage and structural racism has persisted from 1619 through the Civil War to the Civil Rights Movement and now in the movement for Black lives. The teaching and learning about the facts of the founding of America create an impediment to the white patriarchy's construction of a heroic identity for America clothed in the democratic ideals of freedom and heroism. To preserve this mythic identity in the present, those with the power to enforce the patriarchal status quo make it their mission to control America's democratic institutions so as to control the political, social, and economic rhetoric that sustains the mythic identity. This form of perverse activism sows the seeds for backlash against anyone or any institution that critiques such rhetoric or that creates space for reasoned intellectual discourse around differing views of established facts. Because higher education institutions have typically been places and spaces for intellectual inquiry and examination, they find themselves in the crosshairs of populist backlash movements whose raison d'etre is to normalize human hierarchy in an attempt to stall unification of American people around democratic principles of equality, realism, and commitment to an interdependent society. Enter the space where and time when American ideals of liberalism, democracy, and the rule of law are visibly under siege after former President Donald Trump lost his bid for re-election, which was deemed by courts and election officials to be fair and legitimate, with no findings of widespread corruption nor voter fraud, that it would have changed the outcome. A resort to violence by a mob of insurrectionists, predominantly white men, storming the US Capitol after being spurred on by a defeated Donald Trump. The language, stop the steal. Donald Trump's brand of illiberalism did not begin and end with the insurrection of January 6th. Instead, his message of make America great again, that campaign has fomented social and political unrest, violence, and discord within the United States. It is on the heels of the now defunct and morally bankrupt punitive memory law campaign, which encompasses the now revoked Executive Order 13950 and the 1776 Blueprint Project now being modeled in state legislation, that is riling his base for the next election cycle. Former President Donald Trump's earned election defeat is being followed up by his supporters, who prioritize the maintenance of power and white patriarchy in the hands of a few at the expense of the many, seeking to whip up everyday Americans to join his base by promoting a distorted version of critical race theory to create fear among the populace, to garner their votes, while at the same time attempting to discredit CRT specifically and intellectualism generally. Those who are attacking CRT and the legal scholars who developed it as a critique of the failures of the Civil Rights Act of 1964 are intentionally misrepresenting and distorting CRT for the purpose of generating gross political theater, to rile up the base to partake in fallaciously challenging facts about the lived experiences of minoritized and other people in America. In this way, the assault on CRT is a thinly veiled threat against higher education institutions for purposes of striking fear into administrators, faculty, staff, and students about the stability of higher education institutions, especially amidst economic precarity exposed by COVID-19. Targeting CRT has had the desired chilling effect on the larger discourse around society's awakening to the reality of the pervasiveness of systemic racial inequality. As well, targeting CRT by mischaracterizing it while simultaneously mythologizing the greatness of an American past is drawing the line in the sand using an us versus them calculus to prime populist voters for the next cycle. It is this exercise in line drawing that is intended to, at worst, paralyze and slightly less Machiavellian, neutralize the liberals, progressives, and moderate conservatives who are being pushed to the margins in American institutions of higher education. The attacks on CRT are only one in a salvo of new and growing attacks on education from K to 12 to post-secondary, with the intention to whitewash America's history of racism and racial oppression. This opening salvo against CRT is a pretext for erosion of freedom of thought and inquiry that should remain a hallmark of higher education institutions. This anti-democratic backlash creates a fervor to elect school board members nationwide, as Dean Onwuachi-Willard noted, under the guise of reforming the public education system by promoting a certain brand of patriotism and a certain brand of pride in American history, which is intended to be a direct shot at the historical truth of America's gruesome acts of slavery and genocide undergirded by its system of laws. The stated objective of this anti-truth movement is to abolish critical race theory and the 1619 Project from the public school curriculum. What could not be accomplished by Executive Order 13950 is now being pushed by state legislation, specifically punitive memory loss. And this is where I really want to turn my attention to explaining how memory laws are being used against truth. Memory laws have the potential to create a body of legally defined and legally enforced knowledge that a government, in this case, state governments through proposed bans on the teaching of CRT, protects from public scrutiny and removes that knowledge from the realm of historical dispute. In this case, state legislation proposing bans on teaching CRT are meant to elevate a whitewashed history of America's complicity with slavery and genocide generally, and its maintenance of systemic racism, oppression, and subordination specifically. Apart from political theater, and dangerously so, the use of punitive memory laws deprives historians, citizens, residents, journalists, and minoritized people the right to challenge constructed histories in some cases, and flagrantly false redemptive histories in other cases. Moreover, memory laws create a tension between principles of freedom of speech, freedom of press, academic freedom on the one hand, and the policies, processes, and procedures a government seeks to promote. The tension escalates when memory laws include punishment, because this feature creates a chilling effect on individuals and institutions who would otherwise seek to engage in open debate and furtherance of a pluralistic society. Thus, the resulting attacks on CRT are themselves undemocratic and indicative of a larger attack on a certain type of higher education. Specifically, the attack is doubly damaging in the sense that white dominance and the power that it wields goes unchecked, allowing it to be built, rebuilt, and reinforced to protect and promote the status quo of white hierarchy, while law and the legal system are used to further embed white dominance through constructs such as colorblind jurisprudence or through codification of state power to silence oppositional voices. Just as Executive Order 13950 suppressed anti-racist speech until its revocation when President Biden took office, state legislatures are using their collective power to silence those who would learn how to critique systemic racism and inequality in America using the lessons of CRT. Such bans are the equivalents of book burning. And this is the point at which higher education institutions must be on guard. Professor Cheryl Harris explained that any kind of thought or speech that attempts to pierce ignorance is by its very nature a radical ideology that white hierarchy is driven to suppress. This means that higher education institutions committed to pluralism are targets of this new McCarthy-like list making. The proposed and enacted legislative bans on CRT are meant to silence anti-racist speech, but it is also meant to perpetuate ignorance. The very existence of CRT is under attack because it creates a path for knowledge acquisition within higher education institutions about how to respond to the politics of hierarchical constructions of history, to displace truth and to erase inconvenient realities. I do not have the credentials to be a CRT scholar myself, but I do have the capacity and the will to be a student of critical thinking, which includes CRT. So through engagement with CRT, I learned about women's suffrage and have been fortunate enough to build a course around the knowledge acquisition. I'm heartened by the tools and the framework that CRT has provided that contribute to explaining and illustrating how structural racism produces racial inequity within our social, economic, political, legal, and educational systems. The students with whom I share learning space have conveyed that the critical work we are doing in the classroom gives them the language they need to engage in discourse, about systemic inequity, oppression, and subordination. With such responses by my students, I'm heartened that American democracy will be rediscovered and rejuvenated at the intersection of two vital democratic institutions, law and education, that share as their cornerstones critical thinking and the capacity to reason and the will to engage peacefully in the face of difference, disagreement, and dissent. Thank you.
Good morning. Okay, come on. I know the subject matter is daunting and at some points depressing, but part of how we lift ourselves in the engagement is to stay spirited. So quick thank yous. I want to thank the Law Review not only for its courage, but its invitation inviting me to be a part of this important conversation. I want to thank Dean Johnson for your wonderful hospitality. My amazing colleague, co-author, and dear friend Angela Onwachi-Willig, who every time I hear her speak just makes me remember why I was so smart to grab her up and make her start working with me. And finally, I want to thank Susie Lee. One of the things that's true of the life of a dean is you are overscheduled and it's almost impossible to get you scheduled for an event in a way that makes it work with other people's schedule. But Susie Lee was relentless, and along with she and my assistant, Don Bell, they did a great job of getting me here. So I know I'm going to go over time because I always go over time. So Professor Flanders, just use the hook and take me off when it's time. So I want to start off by saying we've heard it in a number of non-explicit terms, but I want to answer first the question pretty quickly on, what is CRT or critical race theory? I think there are numerous answers to that, multiple, complex, but I want to reduce it to my own and to try to simplify it for the purposes of this conversation. That critical race theory is both a scholarly enterprise and an anti-subordination movement that arose out of the tradition of American legal realism and critical legal studies, but in a manner that sought to complicate racial and civil rights discourses and to articulate the importance of subject position of the speaker, right? That who is speaking matters as much as what is said in the context in which words are spoken. So according to a recent article, founding movement scholar and friend Kimberly Crenshaw averred that CRT sought to critique how the social construction of race and institutionalized racism perpetuate a racial caste system that denies people of color the privilege of full citizenship. The scholarship that arose under the banner of CRT described how present-day racial politics and performance are tied to practices of racial spoils and exclusion that have long permeated institutions and social systems. Professor Crenshaw's own work demonstrates, however, Professor Crenshaw's own work, however, demonstrates that CRT is not merely about race, but rather about assessing overlapping and reinforcing forms of subordination tied to various markers of social identity, such as gender, sexuality, and class. The irony of the recent attacks on CRT is that CRT has been a part of law school curricula since at least the early 90s and has served as a significant lifeline for both the generation of law students and legal scholars who have craved a different orientation to law and society and the materials we use in law school, one that more closely reflects or approximates the lived experiences of marginalized people. This has been one of the animating sort of purposes and goals of our CRT, to give voice to these students and scholars. CRT, however, has not been without controversy. Since its formal creation in the late 80s, CRT has been significantly maligned by some scholars, jurists, public officials who have criticized CRT's goals, theories, and methods. Legal scholars such as Daniel Farber and Susanna Sherry, Ann Coughlin, and Daniel Subotnick, and others, such as Judge Richard Posner, have criticized CRT as endorsing virulent identity politics. Additionally, CRT's methods have been described as little more than storytelling, and CRT discourses have been accused of lacking objectivity and neutrality, which are hallmarks essential to law. At the time of the initial attacks on CRT, it wasn't only the discipline or the movement that was attacked, it was actually the leading scholars of the movement, such as Derek Bell, Kimberly Crenshaw, Richard Delgado, Charles Lawrence, Mari Matsuda, Pat Williams among them. They were described as the lunatic fringe, and that their work seemed to be beyond all reason. They also were called radical multiculturalists. This was true even though CRT, like American legal realism and critical legal studies before it, belonged to a long tradition and history of theoretical frameworks that had challenged and deconstructed formalist legal claims and conventions. So in some ways, CRT emerged out of a tradition of this type of critique and deconstruction, but somehow it was treated very differently upon its emergence, something that was dangerous per se almost to the legal profession and to legal academia. We thought that we had moved past those critiques as in the intervening 20 or so years, CRT has become a pretty, I don't want to ever call it tame or safe because it's not, but it's become a pretty accepted part of the canon, accepted part of the curricula, at least within the space of law school. But as the times have changed, so have the critiques. And so recent events have once again placed CRT under a public spotlight where certain majority interests now have sought to vilify the movement and its methods, and to my mind, without having a great deal of familiarity with actually the aims or approaches of the enterprise. And this new wave of attacks, which we've seen emboldened by the executive order that Dean Conaway spoke of from the fall of 2020, we have seen efforts to not only mischaracterize CRT, but also to ban CRT and to limit the principles that are core to its founding, to somehow ensure that it does not move outside of the space of law school, potentially to infect other domains. The current attacks, however, are different largely in two respects. One, I think they're much more in the public domain and not confined to discourses between scholars. And they seem to have morphed into a claim about education more generally and about what is appropriate to teach our children in terms of the history of this country and the way in which racism has or has not been an important construct for creating the realities under which so many people now live. So I'll start with the executive order and describe a bit of the new attacks, describe what I think they get wrong in some ways about CRT, and then suggest why I think we are in this moment of attack and what we might do about it. So as Dean Conaway talked about in the fall of 2020, then President Trump proposed Executive Order 13950. It basically prescribed limits for diversity training for entities receiving federal funding. And although it never actually mentions the word critical race theory, it certainly seems to implicate theories that were prominent within CRT and attempted to limit their impact on diversity training. So for example, the order targeted any viewpoint of America that was grounded in hierarchies based on collective social and political identities rather than in the inherent and equal dignity of every person as an individual. The order further claimed that this ideology is rooted in the pernicious and false belief that America is an irredeemably racist and sexist country. In section 2 of the order, which defined divisive concepts, it said that divisive concepts were those that promoted race or sex stereotyping and scapegoating, and they would be prohibited in theory by preventing certain types of ideologies or perspectives from being included in the training. And the types of things that CRT has routinely dealt with since its inception were the very types of things for which there was concern. For instance, volumes of CRT scholarship have been written about extensive histories of racism and sexism in America, the lasting effects and associated race privilege attached to slavery, and the race bias attendant in ostensibly meritocratic systems. For entities receiving federal funding, covering each of these topics would have been impermissible under Section 5 of the order, as would much of the other content of CRT scholarship. And so we started this moment as a sort of moment of capture and promulgation of an attack on an idea that speaking truthfully about the history of racism in America and its current effects is somehow dangerous to society. And though Trump and the executive order are gone, the attacks introduced therein remain and have become much more explicit. Starting with alt-right critiques such as those from Manhattan Institute fellow Chris Lupo criticizing the Marxist leaning of CRT, the fight has moved from the executive order to Congress and state houses, where legislators have condemned CRT as promoting racism in multiple contexts, and a number of governors have sought to specifically ban CRT from public school curricula. A particular element of these attacks is that they seem to revile CRT without appearing to have a detailed understanding, or even in some cases, an even cursory understanding of what it actually is. And I'll just give you a few examples, both individually and sort of some data that suggests those who are very afraid of it don't seem to have engaged with it on any deep level. We do have a situation in which this has become the new sort of flashpoint of the alt-right in terms of political discussions of race. And on Capitol Hill, at least 39 Republican senators said history education that focuses on systemic racism is activist indoctrination. That's from the New York Times. And then in a recent study where there was detailed outreach to lawmakers, 46 lawmakers in 23 states who have either introduced or supported anti-CRT legislation were asked, what is critical race theory? How do you define it in your legislation? And what would educators be banned from teaching? Most of them did not respond to this outreach. And the author said, we will update you when we receive the answers. They received very few answers. And when they did, they actually start receiving sort of rhetoric that was being promoted by then sort of media outlets that had jumped on the bandwagon to start defining critical race theory in very weirdly racist ways. And so not only was there this kind of, appeal to both state and federal legislatures to jump on board and attacking CRT before they even really understood it, there were people who were willing to even go into press conferences and say, I want to save our children, I want to save them from CRT, who at the moment they were asked about it said, well, I can't tell you what it is right now, but it's socialist and it's dangerous. I mean, one example was sort of Representative Chris Pringle at the time he was asked about it, said he supported the ban and could not answer what CRT is. Since almost all of these representatives who early on could not have now been fed rhetoric that is anti-CRT in nature. And now, for example, if you ask Representative Pringle why it is he's against CRT, he says, he gives the party line, it teaches that certain children are inherently bad people because of the color of their skin. And so I've been studying CRT for over 25 years, and I must have missed the large group of articles that actually promotes this, because I've never read that in any of them. It's also the case that former President Trump, along with others, have defined CRT or described it as child abuse in the way in which it captures innocent children and promotes stereotyping. Again, not within any of the literatures or canons I've read. And more recently, former Secretary of State Mike Pompeo tweeted on CRT that it was dangerous because it taught that the foundation of the United States was flawed. And here's his quote: if we teach the founding of the United States of America was somehow flawed, that it was corrupt, that it was racist, that's really dangerous. It strikes at the very foundation of our country. I would say one need not look to CRT for a claim that the founding of the country was racist. As scholars have noted for years, Article 1, Section 2 of our Constitution did that when it regarded the descendants of slaves of African descent as 3/5 of a free individual for the purposes of determining congressional representation. Now, true, the country sought to address this inequality and the Constitution through the ratification of the Reconstruction Amendments. This, however, does not change the historical fact regarding the original text of the Constitution, and it is not CRT that has somehow produced this. It is the true history of the country that apparently the critics of CRT are afraid to have discussed because of its danger to children. Now, again, it is now one of the things that is sweeping the country, is in particular conservative states, is that it's being banned from school curricula. Governor Greg Abbott in June banned it in Texas, even though historians at the University of North Texas said he seems to misunderstand what CRT is. Critical race theory is a theoretical framework that helps researchers look at how racial inequity has been built into American social systems over time and how inequity affects those social systems today. And it did not appear that that was what he was talking about when he was talking about, again, the radical sort of descriptions of race that are somehow harmful to children. Governor DeSantis was so worried about CRT that it's preventing him from running for president. He says, he is too busy trying to support the eradication of critical race theory and making sure that parents have the ability to send their children to the school they want. He described the teachings of CRT as false histories and says that they would denigrate the founding fathers. And so there's this playbook that basically in some ways claims that CRT mischaracterized history when actuality all it does is trace the empirical, social, political effects of slavery through Reconstruction, through the civil rights periods, to now, and ask questions about what are the disadvantages to those who have suffered discrimination, what are the privileges to those who have not. But so on the one hand, they seem to be very concerned about its mischaracterizing history, when in fact it seems to only accurately reflect the history of race in America. Secondarily, there is this bogeyman of danger to children, somehow that you will teach children that they are bad, that they are oppressors, that they somehow are inherently captured by stereotypes that cause them to treat people wrong, when I think really CRT was never articulated as a movement that was designed to be introduced, I think, in primary and secondary curricula. But to the extent you're borrowing from it, what it should be asking those children to do is ask about the experience of people who are not you. Right? Ask about the experience of what you might understand as what it's like to be different based on your experience is not what others of a different race, gender, class have experienced. And I think if you actually look at what CRT suggests in its doctrines, it's asking us all to accept that even though typically we talk about discrimination and racism in terms of just what it means in the lives of the discriminated, it's asking us to be a community that says, aren't we all a part of the hierarchy of discrimination from our very sort of inception to this moment? And don't we all need to do some work to take accountability and to make things better? It's not asking anybody to raise their hand and say, I am the oppressor, and what I would like to now do is not, act in accordance with a stereotype related. So my sense is these new flashpoints, why are we seeing them? It's clear that before they sort of alt-right media introduced scripts about it, that most of the politicians who were supporting it were not at all very well familiar with CRT and simply were responding to a page out of the sort of playbook that says this is our new discussion point in and around race. And I asked the question, well, if it is the case that before sort of 2 years ago, Angela's point, right, that you go from 3 mentions to 900 mentions on Fox News, what is fueling this? And I want to suggest 2 things. So on the one hand, I do think that there was a particular moment post George Floyd that we saw as hopeful, because in that moment, so many Americans came together to say, I did not realize that the stories of racialized police violence that African Americans and other poor people of color have been telling for years were as true as they have always been, but in a dramatic fashion witnessed the ways in which the lives, certainly of African American men, vis-a-vis the police, did not matter in the same way as others. And so in this moment, there seemed to be an opportunity in America for us to come together across race to acknowledge this problem and for the potential for some larger structural intervention. And there's a sort of one of the issues is that this potential structural intervention is at odds with sort of the alt-right's playbook on how race exists in America. And the moment post-George Floyd, although it was a very specific and gruesome incident, it caused us to have to grapple with the claims that CRT and other scholars and scholarships have been making for a long time, which is that our real issues with race are institutional and structural, much more so than a matter of individual or one-off interactions. And so in some ways, this theory of, or this approach to turn toward addressing this as an integrated community and to do so looking at structural and institutional forms of racism was a problem. And it was a problem that you needed to create a distraction to return to a different theory of race. And I actually think the theory of race that was being attempted to be preserved is the theory of post-race, right? That we are largely past racism in this country, and that to the extent it exists at all, it is among a few outliers, individuals who are engaging in deviant conduct, but we don't need large governmental interventions. We can handle those individuals. And so part of making CRT the boogeyman was to undermine this moment of coming together for structural intervention to re-situate the narrative around racism really doesn't exist. To the extent there's any problem, it's individualized, and we certainly don't need to malign American history or harm our children to prove otherwise. And so in some ways, there's that political goal, but I also think that part of the sort of attacks on CRT have just been to create political unity and the alt-right, because if you, again, there are polls that look at this. There's a Yahoo News YouGov poll that looked at 1,600 adults in June of this year and said, how many of you know what CRT was? Of the 50% of them who knew what CRT was, most of them only knew of it in the context of the recent political attacks, and of them, 49% of them had heard of it, were against exposing children to it, right? And so this has been an effective campaign, really not only, I think, to push back against unity around fighting institutional racism, but I think it has also been to galvanize a political division about how racism operates and to recapture a narrative that the people who are promoting CRT, who actually weren't attempting to promote it in primary and secondary schools, but those who support CRT are somehow supporting a vision of America that it is self-racist, that is somehow opposed to what we believe, which is that essentially race is no longer a huge issue, but that, to the extent we are talking about race, it should be in a very limited context. Then a recent Time magazine cover story said conservative advocacy groups, legal organizations, and state legislatures have mounted a campaign to weaponize the term CRT because they believe that fighting it will be a winning electoral message, right? This is, so on the one hand, it has just a kind of pushback against the intervention, but in other ways, it has this reaffirming of a kind of political divisiveness that it becomes the method to now align people. Being anti-CRT is another way in which we define ourselves, and through means, again, that we can be proud of, because CRT is anti-founding fathers, is anti-history, is anti-children. And so you've captured now this message that is, again, inconsistent with most of what anybody who studies CRT would agree with, but is certainly, for people who are unfamiliar and who get it through sound bites, something that is likely to scare you. So in my seconds before I sit down, what do we do about this message? Well, you do what CRT scholars have always done, right? You push back with what we call in CRT literature the counter story. And I will just add, I believe to be the truth, right? What is the intervention we were proposing post George Floyd in terms of looking at systemic and institutional racism as a way of thinking about correction and why that's important? We push back against the descriptors that say CRT wrongly labeled America as racist and sexist. I think the history of America shows we have had problems with race and sex, and CRT did not create them. It merely attempted to document them in a way that added perspectives to the understanding of what that tragedy was. So in some ways, I'm merely saying speak truth to power, but in another way, I'm leaning both on the CRT tradition of narrative. It matters what I say, about my experience in this country. For so long, it didn't. So in a time when I can be heard, I should be heard and will be heard, especially when the way in which my life or the lives of people similarly situated are being characterized do not seem to align with our own lived experience. And then second, I want to, Derek Bell. Derek Bell, by the way, is pre-CRT. Derek Bell was doing CRT before we called it CRT. CRT actually gets formed in this very particular moment in the summer of 1989 by a group of scholars. He was there, but he had been writing for several years before this in ways that have later become foundational articles within the canon. And one of Derek Bell's articles that is a favorite of mine is about making the record, right? And so we know as counsel, we make the record as a way potentially to win our current case, but at least if we don't win, we're preserving our best argument for the appeal for the next round. And my sense is we're in an ongoing fight for, in some ways, the truth, and in some ways, the soul of an America that is open to, that is more committed to telling the truth about our history and then addressing it than merely washing over it and making a claim that it didn't exist or has no present day repercussions. And so we are in that battle. It counts right now that we respond to this, but it also counts that we make the record, because this is not the first, nor will it be the last set of attacks that are on CRT or progressive movement making. And if we want to be able to effectively win the long game, then we have to make the record today for what the moves that were made, the places where sort of false histories and narratives were created, and how we responded in order that at least, you know, and if not my future, that of the next generation, that we will be able to perhaps get to a place where if we don't, you know, sort of reach the type of equality some many of us dream is possible under the 14th Amendment, that we will at least make inroads toward it. So thank you very much.
Okay, this guy again. So they said I could take my mask off just for a second. Bill told me to make sure that, you know, the face recognition software works. So I want to first thank Bill again and just, you know, and thank Angela for a wonderful presentation earlier today. And really yesterday, started yesterday. So you have a new fan. We'll be in contact very, very soon. So I thought I would think about, as a respondent, you know, it's hard to on the fly just kind of take notes and say, okay, here's what synthesizes both speakers. I think I can do that, but I also want to share with you some thinking I've already been doing about the relationship between African-American studies and CRT. And one of the things I want to remind us in this piece, you'll see, is that in addition to the kind of genealogy that our colleagues have laid out this morning, Black studies is also part of the roots of CRT. And so I want us to think about that, and I'll show a couple of examples of that, but I want to tell a story first. In November of 2019, I was on a flight to Honolulu, not St. Louis, for the American Studies Association annual conference. And on that flight was Aubrey Hendricks, the great religious scholar, Farah Jasmine Griffin, his partner, and Kimberly Crenshaw. And about an hour out from Hawaii, there was movie turbulence. I don't know if you've ever been to Hawaii, but there gets turbulence in the fall, which I guess is some seasonal thing across the Pacific. Don't get me started on that stuff. Movie turbulence. I mean, like absolutely, and I'm gonna say this in a Black studies way, when white folks start praying, you know we in trouble. Folks start breaking out hymnals and songs, and I said, this can't be. But I remember that Kimberly Crenshaw was on board. So my first thought was, there's no way the creator is taking us out, because like all the Black studies is on this, this flight. But secondly, if we go down, I'm going down with Kimberly Crenshaw. And I feel that way today. That if we go down, I'm going down with Kimberly Crenshaw, which is to say that if these attacks are successful on CRT, then I would rather be on her side than on the side of people trying to ban CRT, which is the most ridiculous idea we could think about. But it also speaks to an anti-intellectual tradition that runs through American culture. And so we have to account for that as well, because Black studies emerges in a context to disrupt that formulation, to disrupt the idea of a Western canon, to interrupt this idea that everything emanates from Europe, that all knowing emanates from Europe, that only things that are beautiful emanate from Europe. So African American studies emerges in this context of disruption. And so CRT, it shouldn't surprise us that the work that it does is a disruptive activity. And we should embrace that. And for those of us who are thinking, what do we do next? Well, we continue to lean into this. We continue to lean into CRT rather than run from it, see what else we can glean from it. What other kinds of work can it do for us? I can't wait until senators from Missouri, senators from Florida, wherever they may come from, start to tackle Afro-pessimism, because that's going to be a fun conversation. And people still trying to digest what Afro-pessimism is. And I'm not about to do Afro-pessimism for you today. But the point is that these are ideas, but they are ideas that are so potent that they pose a threat. So in many cases, we should applaud Kimberly Crenshaw for being on the tips of the tongues of folks who would never read Kimberly Crenshaw to begin with, who never heard or appreciate Du Bois, for example, who would never think about a person like Carter G. Woodson as having anything good to say about American society or about the origins of American society. So we have to understand that this conversation about history, about the role of law, is a contested terrain. We should embrace that. We should raise up young people to embrace that. And I think that the more we do that work, the better off we'll be, the closer we'll get to a democratic future that we think that we can appreciate, the closer we can get to a sense of justice, racial justice in particular, the closer we can understand intersectionality as not just a tool, but a lifestyle, way of being, a modality. Those are the questions that we have to really address for ourselves. And that's an individual question of learning and deep knowledge, but it's also an epistemological question and an ethical question in terms of who we think we say we are to the world and to ourselves. So I thought that just in brief, I want to just say flatly, we don't have to defend CRT. It can defend itself. So we don't need to take a defensive posture towards CRT. I think that we need to continue to teach CRT, but I don't think we need to be defensive about it. I'm not defensive or apologetic about African American studies or Black studies. I've crossed that bridge already. There used to be a time where people did need to apologize or say, hey, yeah, we're actually born out of sociology. Hey, we come from English, and kind of substitute these more traditional disciplinary frameworks and then say, hey, and we also do this over here. At this point, we don't need to go there. It's 2021, it's not 1961. But the point that I want to make is, what are we reading? How are we preparing ourselves? What is the role of the academy in this new effort that we are embracing at this moment? And I believe that the role of the academy has several functions. The first function is really to think about, how do we use old knowledge with our experiences to create new knowledge? That has to be always part of our project, the new synthesis, the new knowledge. It also has to be a space of debate, an open debate. It can't be a space of silencing. It can't be a space of fear mongering. It can't be a space of ridicule. It has to be a space of critical knowledge production. It's called a university. These are called universities. They should be about ideas. But then there's also a state function. And I think that this is the issue that we're encountering now, which is, what is the will of the state? And by the state, we're talking about individual states, but also federal government. What is the will of the state? And is the academy, is the university, the modern university, doing the will of the state? And what role does it play in helping to amass state power over what we know? And this is the epistemological challenge and the ethical challenge as well. So this is serious business that we have to confront. We can't handpick the scholars that we want to read, right? How many of you routinely read Black authors, for example, or routinely read Indigenous authors, for example, right? Within the field of law, right? And so the point is that we have to do more than what we're doing if we're going to do right by Kimberly Crenshaw. If we're going to go down with Kimberly Crenshaw, we have to really do the work, the archival work, the insurgent archival work that is required, that she's asking us, she and Derek Bell and many others are asking us to explore. This is what I think is the common refrain in both the speakers we heard today. So before I conclude, I wanted to make sure that we hear from Kimberly Crenshaw herself on this question of the relationship between, well, her origin. I'm not going to go into the relationship between CRT and Africana Studies. We could talk about that. But just her origin story, if you will, in terms of how she came into her own as a thinker, as a scholar at Cornell University, under one of the chief architects of the modern Black Studies movement, a man by the name of Dr. James Turner. She says, if Black Studies as a discipline produced, say, the Marines, I would say the Africana Studies Center produced the Delta Squads. We were the forces that were unleashed in the comfortable and hallowed halls of American law schools. Dr. Turner in particular was our drill sergeant, our instructor. He was the one who showed us how to do the things we needed to do, how to map where we were. He reminded us that the institutional battles, what the institutional battles were all about. He was the one who let us know that there was an objective to be fought in these engagements, to decipher the map, to know where it was that we were going and where we were coming from. In Africana Studies, we were taught the essential tools of survival in hostile terrain, to go deep into that terrain and to do work there. We learned the importance of teamwork and community and intellectual production and in the development of our epistemologies. We learned the importance of reaching out to allies when they are necessary, the importance of mobilizing masses and coordinating smaller formations when those are necessary. In the Gramscian term, we learned to engage in the war of position. This is Kimberly Crenshaw talking about how she came to CRT through, not around, through Africana Studies. So as we think about the origin story of CRT and what we believe we are defending now, what happens when we think of CRT as part of Black studies, not subsuming one underneath the other, but as equal strands in a search for justice in law and in the academy. Thank you very much.
All right, thanks. So we'll turn now to discussion, and I just want to remind you, if you raise your hand, if you could type your question in the chat, that'd be great. And Dean Conway, you had a question addressed to you, and so do you want me to just read this verbatim? All right, so it's kind of long. I'll try my best. Dear Dean Conway, however truthful your presentation was, how do you reconcile the fact that much of what you said could be easily dismissed as ad hominem? Those on the spectrum that attack CRT will never have their perspectives change, and the battle for minds is in the margins of the middle. Yet your words are not incisions meant to allow learning and calling in, but are instead an unapologetic chainsaw. meant to force adherence? Do you think this is an issue in the larger conversation of educating the masses? So I'm the.
So thank you for that question. And I was hoping that the author of the question would actually arrive at the answer based upon the presentation by Dean Mario Barnes, especially. But, you know, the definition of ad hominem is that, you know, there are certain shrill arguments directed to an individual. And I will say, the beauty of Zoom is you can actually like go through all of your comments to sort of check and discern whether you actually had any ad hominems. No, I didn't. And I think that, you know, the only thing I can point to is when you actually name things like white patriarchy and hierarchy and dominance, those things may feel like an attack, but those have political meaning and those have social meaning, and it's not directed at individuals. Now, if someone, again, wants to misconstrue those comments as being waged against individuals as opposed to systemic racism and institutional racism, and that's where what Dean Mario Barnes really brought home in his presentation, you know, there is not much I can do except dissent, disagree, and to speak my truth in a peaceful way. And that is modeling democratic ideals. And so I'm happy that we read the question completely, because we should be practicing exactly this. And I would welcome the entertainment of any additional discussion on the topic, because that's exactly how we come to an understanding, a perspective around facts, around perspective, around opinion. So I would just say that. And if there was something else, please let me know.
All right, and if you're in the room and you'd like to ask a question, you can step up to the mic. We have one question for Dean Barnes, and that is, what's the relationship between CRT and socialism? Is there some? Oh boy. Yeah, I should.
So I'm green is good. So, I don't want to mischaracterize. So CRT has a number of, I think, foundational underpinnings. One of them is in the tradition of ethnic studies and Black studies discourses. Some of them are built on traditional, civil rights discourses, but there's a part of CRT that's built upon both consonantal philosophy and at least the theory of the state, borrowed from the Marxist tradition, at least in terms of talking about the plight of subordinated people. And so two things are true, that many of the people who have leveled the new attacks have sort of focused almost entirely on this point to justify the claims about being socialist and Marxist. I think I mentioned, I think it's Chris Rufo, who's a Manhattan Institute fellow, has been arguing back and forth with the Times and the Post about this. And I actually have pushed back and said, I don't think it's important to try to justify or respond to the origin story of CRT. It emanated from many traditions, including the specific interventions in the legal academy tied to American legal realism and critical legal studies as sort of forebearers. And so the point is, although it is a part of the origin story, it is more important to focus on what has been the recent and I think historical importance of the scholarship produced in CRT, and where it has sought to both create new interventions and the ways in which it has sought to complicate our understanding of racial discourses. And so my sense is I don't want to try to claim that there was no connection, but I also don't want to give greater importance than we should to this notion that part of the origin of this movement is tied to something that the alt-right seems to malign. I mean, I think, I'll say it, but it'll become buzz, sort of phrase from others. I might start with what's wrong with socialism, right? But the point is, there is a particular group for whom associating anything with socialism creates a kind of skepticism that immediately gives your critique of it legitimacy. And so my sense is, if you look at CRT scholarship, sort of starting with Derek Bell, moving through the early 80s pre-founding, like Charles Lawrence's germinal piece and the ego and reckoning with unconscious races, you will see that they don't speak explicitly about this relation to Marxist thought or socialism. You will see that when you start to see the scholarship that arises about the formation of CRT and the stories about how it actually came to be a formal movement, that the work of Kimberly Crenshaw and others speaks to how their project was informed in part by these things. But again, if you look at the arc of the scholarship, what it's doing today, its premise today that I think we mostly believe is important is that we have to understand that the history of racism and other forms of subordination are not historical artifacts, but they are, a cancer that has propagated within our society, that has continuing negative effects, and that when we seek to now address or redress them, that we need to do so in ways that honor that there has been a long history of these effects, and that with regard to our current moment, that we can no longer speak of how we respond in terms of individual discrimination, but we have to think about the way now the cancer has become prevalent in our institutions and has, propagated through systemic and not individual needs. And to me, that doesn't have much to do with socialism, and I think it has everything to do with us being honest about the tremendous negative consequences of our mostly both ahistorical and truthful dealing with the impact of race.
Okay, I agree with all that. I think I also want to say that would be a good question for Brendan as well. I think, yes, absolutely correct in terms of I don't disagree with anything my colleague just said. I would just add that the way in which socialism is used as a boogeyman, we should really think about the relationship between how it's being heralded. That same kind of energy is being used at CRT towards CRT. So instead of asking the question of the CRT and socialism, right, the very construction of the question is meant to invoke a kind of 1950s fear of anything that speaks to redistribution of wealth, and then more particularly redistribution of power, right? And so I think that those are things that we have to think about, and I would recommend that folks read a short essay called The Redistribution or The Distributions of Whiteness by a scholar from Yale University, Roderick Ferguson. That will help you really think through these questions. And then also read The Propaganda of History of 1935 by W.B. Du Bois, which was part of his book, Black Reconstruction. And I think if you read those two texts closely, then you could come to having a little more flavor, a little more texture to why that's a problematic construction in the first place. Thank you.
Firstly, thank you so much for doing this for us. This question is for Mario Barnes. As powerful as narratives are about CRT, do you think that the public's lack of objective data might be one of the reasons the attack on CRT is so successful today?
So I want to suggest that although narrative has been a very important methodology within CRT, that CRT has never been opposed to certain forms of data. I think CRT has been in some ways at times skeptical of certain types of quantitative data, but certainly has always mostly embraced myriad forms of qualitative data. And actually in the kind of new subfield that has emerged, ECRT, empirical methods and critical race theory, there's been this, and we owe UCLA scholar Laura Gomez and Berkeley law and public health scholar Osagi Obasaki for being sort of founding members of this. It's been a movement that has sought to intentionally ask empirical scholars to think more critically and in complicated ways about race, and ask CRT and race scholars to think about the importance of including empirical data, to include, I think, quantitative data in our projects, which I love the work of Angela Wachi-Willig, because she, among other scholars, do this. And so the notion is, I think, nothing about our tradition and commitment of the importance of narrative suggests that we are anti-data. And I think, again, there are data which support the claims of CRT scholars that the recent attacks have simply been both ahistorical and untrue. And here's the thing that bugs me the most from this question. Almost all data that looks at the lived experience of African Americans in this country, in any category that you look at in terms of wealth attainment, education, statistics related to incarceration, or on all the categories in which you have data, it is clearly the case that African Americans do less well than others. And when it suits, political motives, people discount those or talk about them as connected to personal behavior and choice, not anything systemic or societal. And you don't have to make it up, right? We have research data which confirm the continuing impact of race in this country. If I never told a story about being wrongfully stopped, if we didn't have the video of George Floyd, there would be data that certainly suggests that all the things that African Americans and others have said for years were true. And my sense of why CRT scholars often talk about a narrative, because it becomes this way to add to a discourse that's often dispassionate and apersonal, another layer upon which to ground the claims. And so my sense is, there's not any avoidance of it, but I will say this: data alone does nothing. I mean, one of my least favorite opinions in in American jurisprudence is McCleskey. I think the data detailing the impact of race in the admission of the death penalty, and in that case in Georgia, was pretty overwhelming. That the race of the perpetrator and the race of the victim in association definitely had an impact on who was sentenced to death. And in the end, the court copped out and said, with regard to the data, it's more demonstrative of correlation than causation, where it's really hard to prove, the but-for cause of anything. But more importantly, they said, this is a social problem, should be handled by, the political system of legislatures. And so the point is, don't misunderstand. You could have lots of data that confirms your theory of the world in terms of discrimination and not have it matter in the way you want it to create change. And so I think both of these things are important, because for those who can be reasoned with, I think there are some for whom the data is important. But I also don't want to belittle the importance of CRT's claim that what I say about myself and how I live in the world to structures of power is important, and to claim that as not important just to me, but for those legal and societal institutions to have to hear.
I think, I want to ask Dean Conway one last question, because we should wrap it up. But Dean Conway, so why at this moment are attacks on CRT gaining such traction? Why is there some explanation of why this historical moment is when this is happening?
Well, I think the expedient answer is we have an election cycle that's coming up. And as my illustrious co-panelists have articulated, this is a sort of us and them battle. It's a winner take all, at least as it is being framed by the alt-right. And unfortunately, we've gone really far afield from understanding that we are all part of this democratic experiment. And so, sometimes, we criticize these political groups on either end of the spectrum, and sometimes the criticism is warranted because what is fusing us together is being ignored. And that's the long range plan, the long range goal of what are we doing to frame the preservation of our democracy for the generations that follow. And I think that that's one of the big reasons.
All right, well, let's thank our panelists. Thanks so much. And let's try and start in about 5 minutes. Thanks.
All right, welcome back, everyone. Good afternoon. We shall resume. I am Dr. Middleton. I am an adjunct professor here at St. Louis University School of Law. I also am a professor of political science at the University of Missouri, St. Louis. It's a pleasure to be here with you today. Our second panel, very interesting topic, critical race theory and the crisis in criminal justice. We have three outstanding panelists today who are looking forward to presenting on this topic. We have with us Professor Ngozi Okedibe, an assistant professor of law at the Cardoso School of Law. We have Professor David Niven, associate professor of political science, the University of Cincinnati, and Professor Anthony Farley, the James Campbell Matthews Distinguished Professor of Jurisprudence, Albany Law School. We will proceed in the order as listed on your pamphlet, and we will start with Professor Okedibe.
Thank you, Professor, for that wonderful introduction and for moderating this panel. And I'd like to thank the editors of the St. Louis University Law Journal for inviting me to speak at this important symposium. I'd like to thank the Dean for his hospitality and having us here. And it's just so amazing to be in this space. Critical race theory has been so critical to me. Critical race theorists such as Dean Angela Onwueke-Willig, Professor Patricia Williams, Kendall Thomas, Dorothy Roberts, they've been critical to how I think, how I write, and my development as a Black woman. And it's just so great to be in this space. And I've loved hearing all the wonderful presentations from my colleagues, and I'm excited to continue this critical conversation. I research and write in the area of law and technology, and particularly I focus on the use of criminal legal technologies and their impact on racially marginalized communities. We see these technologies proliferating in policing, bail, sentencing, and parole. And while they have a significant impact on all, they have a particular impact on racially marginalized communities. And this is because these technologies reproduce the very racial and socioeconomic inequities that they are supposed to eliminate or reduce. And this is because these technologies are colorblind, and these technologies are developed with data exclusively from criminal legal institutions, institutions that produce racialized data. And on top of this, members from racially marginalized communities are often unable to stop, shape, or influence the use of these technologies. And the reason we see this is because these technologies, the paradigm that governs them, is democratically exclusionary to these communities. And I want to talk about this democratic exclusion, and I want to talk about what CRT tells us we can do about it. Because this democratic exclusion is critical for why we are seeing the proliferation of racially biased predictive technologies that support racial hierarchy in the criminal legal system. So in terms of a roadmap, I will use the example of pretrial algorithms to situate us and talk about how these technologies support racial subordination. And I will spend this talk as well as this project unpacking how the paradigm governing the use of predictive technologies like pretrial algorithms is democratically exclusionary to racially marginalized communities. I will talk about the harms that this democratic exclusion enacts. And I will end by thinking through how critical race theory can help us think about how to respond to this problem. So to set the table, a bit of background, criminal defendants are subject to a pretrial hearing to determine whether they will be detained before trial. For many, that hearing is affected by the risk prediction of a risk assessment algorithm. And the reason is because across the country, we are seeing jurisdictions turning to these pretrial algorithms as a response to the problem of racialized mass pretrial incarceration. The idea behind using these algorithms is that the information they produce will enable bail judges to make pretrial release and detention decisions on the information produced by these algorithms, as opposed to from the racist bias that often determines and drives these decisions. But what we are seeing is that the use of pretrial algorithms has actually reproduced existing inequities. And in so doing, has essentially left in place the racial disparities that exist in the pretrial system. And the use of these technologies has birthed a movement of activists, policymakers, and scholars who are critical of the use of pretrial algorithms, as well as the algorithm project generally. And their work has shown how pretrial algorithms are deployed in an opaque, democratically exclusionary way, and that they produce racially inequitable predictions that support existing racial inequities in the pretrial system. And so I'm going to focus on how the paradigm governing these pretrial algorithms is how these algorithms are able to support racial hierarchy in the pretrial system. And it's important to take a little bit of a step back to talk about how the criminal legal system itself is democratically exclusionary to racially marginalized people. And a number of scholars have focused on this. And the reason is that the criminal legal system essentially doesn't take into account the viewpoints, is unable to be affected by the communities that are most likely to come into contact with the system as defendants, as arrestees, and work such as Professor Jocelyn Simonson really focuses on this democratic exclusion. And the pretrial system is no different. The pretrial system is also democratically exclusionary to these communities. And we see that the pretrial system is structured to take into account the interests, to promote the interests of members from wealthier, whiter, and more powerful communities that have the economic and political resources to influence the election of bail judges and others who are in charge of the pretrial system. Now, this state of affairs has had two critical consequences. It has meant that as outsiders, members from racially marginalized communities are experiencing disproportionate incarceration within the pretrial system. At the same time, because these communities lack the same political and economic resources as more powerful communities, they're unable to render bail officials and others in control of the pretrial system accountable for this disproportionate incarceration, even though this disproportionate incarceration is hampering their ability to collectively exercise democratic rights. And as Dorothy Roberts' work shows, mass incarceration, the concentration of the criminal legal system in racially marginalized communities effectively denies members of these communities the ability to exercise full political, economic, and social citizenship in this country. And the paradigm governing pretrial algorithms is similarly democratically exclusionary to these communities. Pretrial algorithms are adopted, constructed, implemented, and overseen in ways that are shrouded with secrecy and not subject to democratic debate and not subject to democratic input. And though this affects all, it particularly affects racially marginalized communities because what it does is it hampers efforts made by these communities to try to address the ways in which the pretrial system supports their racial subordination through disproportionate incarceration. Additionally, it makes it so that members of these communities are unable to stop these pretrial algorithms or shape how they're constructed so that they do not proliferate racially biased predictions. And at this point, it's important to think about why these pretrial algorithms produce racially inequitable predictions. And the reason they do is for two reasons. One is that they use colorblind factors that operate as racial proxies. And we know, as critical race theory tells us, that colorblindness is a way in which racial hierarchy is facilitated. And the colorblindness of these tools enable these tools to further racial inequity while naturalizing and legitimizing it. At the same time, the reason that these pretrial algorithms facilitate racial inequity in the pretrial system is because they are exclusively designed with data from criminal legal institutions, such as the police, pretrial service agencies, and the court system. Institutions we know have racially inequitable data. And the data from communities most impacted by the criminal legal system, data that if utilized could change the kinds of predictions that these algorithms make, is not utilized. And critical race theory can get us to think about why it's not utilized. One of the reasons is epistemic oppression. So these two issues have essentially led to the production of pretrial algorithms that appear neutral, promote existing racial inequities, and at the same time, allow our society to maintain racially inequitable pretrial incarceration practices in the name of protecting public safety without having to first interrogate how the relationship between incarceration and public safety has been shaped by racism and racist tropes of Black and brown criminality. Having a paradigm in which those who are most impacted by the system are unable to have a say about these algorithms has essentially produced algorithms that facilitate the status quo. Now, what do we do about this democratic exclusion? What do we do about how it facilitates the production of algorithms that support the criminal legal system's role in racial hierarchy? Well, one route would be to abolish the use of these technologies, and professors like Wuha Benjamin have argued for that. My co-panelist is going to talk about abolition, so I won't talk about that now, but that's one route. And critical race theory would also tell us that another route would be to try to pursue strategies for inclusion of these communities in the paradigm governing pretrial algorithms under the idea of interest convergence. And another theory and another approach to go forward would be community control. I'm going to talk about that. And in this project, I want to expand on my prior work. In my prior work, I've talked about including these communities in the paradigm that governs pretrial algorithms under a theory of interest convergence. But here I want to talk about the idea of community control and what that could mean and what benefit that could have. When it comes to community control, I'm suggesting that these communities be endowed with complete power over if and when pretrial algorithms are used. They would have complete power over how these tools are adopted, implemented, and overseen. And there are two benefits with this proposal. One, it would redress the democratic exclusion that these communities currently experience by enabling them to have control over these tools. The second important part about this is that it could really bring about radical change to the pretrial system by enabling a deep interrogation of the racial power and subordination within the system. As targets of the system, as outsiders, members of racially marginalized communities possess Antithetical knowledge, as critical race theory tells us, about the system's operation that could be used to combat its racially subordinated features. Moreover, given the growing importance of these algorithms in pretrial policy, power over these algorithms can mean incorporating these communities' views within the pretrial system. It could enable these communities' values and goals to actually be part of the pretrial system. It could even enable a dismantling of the current pretrial system and the reconstitution of a pretrial system that doesn't have these racially subordinate features. So to sum up, the proliferation of pretrial algorithms and criminal legal technologies generally has operated in a way that has been democratically exclusionary to these communities. Failure to respond to this problem of democratic exclusion raises deeper questions about whether pretrial algorithms or criminal legal technologies can be decoupled from their current role in racial hierarchy. If we're sincere as a society in ending racialized mass incarceration and trying to eliminate racial inequity, then we have to be willing to cede power to those most impacted by the system. And this means empowering them with tools such as pretrial algorithms, criminal legal technologies, and other tools in order to radically reform the system, change the system, or even dismantle and reconstitute it. Thank you.
I want to echo something that some of my colleagues here have said about the importance of this topic in this moment. I teach in Ohio, and Ohio, like many places right now, there's a bill pending that would ban the teaching of divisive concepts. And among those concepts is asserting that there's discrimination in the United States, or that there was, or that there is. And get this, the penalty for teaching a divisive concept at the university level is a 25% reduction in state funding per instance. Let's think about that. In a week, I could cost the university its entire state funding, and I'm gonna have to do it because this is a war on ideas. And if we don't have ideas, we don't have a university. So I want to echo the congratulatory comments to the dean and to your law journal staff for having this conversation. And whether you like what you hear and agree with it, or dislike what you hear or disagree with it, it's inordinately valuable that we have the discussion. I worked on a project that cataloged the outcomes of 4 decades worth of capital murder cases in Texas, 15,394 cases. Here's your bottom line. Somebody asked about data earlier. Here's your bottom line. Across all those cases, if the victim was white, it was 3 times as likely for that case to result in a death sentence than if that victim was African-American. 3 to 1. Now, I'm a political scientist. I do social science research. We love the concept of statistical significance. If something has a 1 in 20 chance of happening just randomly as noise, we consider that statistically significant. We put a star by the number and we publish it. If something has a 1 in 100 chance of happening randomly and not being a substantial relationship, we put 2 stars next to it, very happily publish it and move on. Something has a 1 in 1,000 chance of happening, that's pretty much where we stop putting the stars on, because at that point it's just bragging. The odds of a 3 to 1 relationship persisting across 15,000 cases is not 1 in 20, it's not 1 in 100, it's not 1 in 1,000. It's not 1 in a million, it's not 1 in a billion, it's not 1 in a trillion. It's 1 followed by 21 zeros. I don't even know what that number is. That is the odds that Texas could perpetuate that level of racial disparity over time if it wasn't the product of an actual systemic effect. 1 and 21 zeros. Just to put that into perspective, for those of you who like to gamble, the Powerball odds are 1 in 292 million. So you don't just have a better chance of winning Powerball than seeing that relationship in Texas. You have a better chance of winning Powerball 1 trillion times than seeing that relationship in Texas. This is a project I worked on with Dean Jelani Exum of the University of Detroit Mercy. We're also in partnership with some scholars at New Mexico State University who helped compile this data, David Keyes and Aram Cho. And I know, and Dean Barnes referred to this earlier, we've seen this pattern before. This is not shocking. We've seen it in Georgia in the famous Baldus study that really sparked an awful lot of scholarship on this. And we've seen it in Florida, and we've seen it in Kentucky, and we've seen it here in Missouri, and we've seen it in North Carolina and Ohio and Oklahoma and Pennsylvania. And I think, as Dean Barnes alluded to, it's important to understand we've seen it, and yet we've tolerated it. There's a line from the majority opinion in McCleskey in which, referring to the Baldus data, they say, taken to its logical conclusion, the data call into question our entire justice system. Well, yes. We're doing this project on the belief that these numbers fit a larger pattern in which African-American victims are devalued. They're underprotected. This is Texas. They're underprotected by a system designed to exact retribution. They're underprotected in a place that prides itself on its frontier justice. Let me give you another number here. If we take just the universe of cases with a white defendant, so the white defendant, if they're accused of killing a white victim, they are 13 times more likely to face a death sentence than if they kill an African-American victim. 13 times. As a thought experiment, I'd invite you to think right now, what if we found out that the coin referees use in the NFL was 13 times more likely to come up heads than tails? The country would come to a standstill. This would not be tolerated for even a minute. Something is 13 times to 1 unfair. We wouldn't accept that for a second if it was going to affect the Super Bowl. And yet this is the relationship in Texas, and it echoes the relationship in Florida and Georgia and Missouri and North Carolina and down the list. Randall Kennedy writes about this idea, this sort of ironic side effect of the stigmatism of stigmatizing racism, which is that we have made it so clearly unacceptable that often the courts won't call anything racist because they apply an impossibly high standard because it's such a devastating conclusion. In the McCleskey decision, this is a quote on what kind of data they would want to see before they would consider our system racist. Exceptionally clear proof. Clear proof would be insufficient. Clear proof would be insufficient. Exceptionally clear proof. Now, it's a natural defense that came up in Georgia. It certainly could be applied in Texas. Well, maybe the nature of the crimes is different. It's not really 13 to 1. There's some aspect of the crime that's different. In Georgia, in the McCleskey case, the state of Georgia argued, quote, white victim cases are qualitatively different from black victim cases, which is to say they argued that they hadn't done anything racist by advancing the racist notion that these crimes are entirely different. Their attorney actually said in district court that African Americans were more likely to die in barroom quarrels, and that's why the victim disparity existed. Well, in the Texas data, I can tell you this. When we break it down by the weapon used, if the assailant used their hands, there's a racial disparity. If the assailant used a blunt object, there's a racial disparity. If the assailant used a knife, there's a racial disparity. If the assailant used a gun, there's a racial disparity. If the assailant used something else, there's a racial disparity. We have in this database cases that did not result in death sentences, of course, and we see the exact same pattern. White victims generate a 10% longer sentence. I'll break it down one last number here for you. A lot of death penalty cases involve multiple victim situations. If multiple African Americans were victims, death sentences occur in about 12% of the cases. If there were multiple victims, one African American and one white, death penalty is applied in about 19% of the cases. If there were multiple victims and they're both white, death penalty was applied in 74% of the cases. And this is a cold, harsh math. It's literally, it takes multiple African-American lives to equal one white life in the Texas criminal justice system. Our next iteration of the project after gathering this data is we're focusing on prosecutors. We're focusing on the role of prosecutors. Let me read to you just a little bit from a write-up about Dallas District Attorney Henry Wade, who was district attorney for a very long time, all the way up through into the 80s and 90s. Henry Wade was the embodiment of Texas justice, a strapping 6-footer with a square jaw and a half-chewed cigar between his teeth. The Chief, as he was known, prosecuted Jack Ruby. He was the Wade in Roe versus Wade. He compiled a conviction rate so impressive that defense attorneys called themselves the 7% Club. Henry Wade, that was literally the lead of a story that later went on to point out that Henry Wade had presided over the most exonerations of any county in the nation. His successor, a couple district attorneys later, Craig Watkins, said of Wade, he had a cowboy mentality. It was archaic, racist, elitist, arrogant. Let me tell you, I promised you no more numbers, but here's just one more. When Henry Wade was district attorney, white victim cases resulted in a death sentence 30% of the time. African-American victim cases resulted in a death sentence 0 times. One of his successors, a couple successors later, Craig Watkins, the first African-American to be a district attorney in Texas, that disparity when he took office was 0. It went from 30 to nothing to 0. The role of the prosecutor in this is incalculably large. And our next iteration is to really dig down into these relationships and into these patterns and consider where these 13-to-1 numbers come from. Chip Brownlow was just home from high school, brought with him his younger brother who he walked home from school. He was a good student, he was a good athlete. He was graduating in 2 weeks from high school, then he was heading to college. Chip's cousin had just returned to the family from college himself. Family was outside welcoming the cousin home. Now, Chip was not killed in a barroom brawl, but in his front yard, and indeed in his cousin's arms, amidst the tears of his family. Terry Don Woodward's family lived next door. Woodward had a white power tattoo. He didn't much care for the Brownlow family. He came at them one day, seeing them in the yard, celebrating the return of the cousin, came at them gun in hand, charged at them, hunted them down, calling out racial epithets as he did so. He fired several shots as the Brownlow family ran for cover. Chip Brownlow happened to fall. With his hands up, pleading for his life, Woodward shot him at close range. He ran off. A day later, the police found him after a peaceful apprehension of following a 7-hour standoff. He was ultimately tried and convicted of murder and aggravated assault. Terry Don Woodward was sentenced to 30 years. Had that situation been an African-American man chasing down a white child, with all those details held the same, would Texas have pursued a 30-year sentence? We would assert in our work that the death penalty has been used as a tool for carrying out bias. And indeed, Connecticut, Maryland, and New Jersey have abolished the death penalty in part with a nod toward racial disparities in the results. Ultimately, we must make the radical choice to uproot systems like the death penalty that allow anti-Black bias in our national consciousness to not only thrive, but to be seen as just. To do otherwise is to perpetuate a system where Black lives matter less. Thank you for your attention.
I'm going to take this off just for the purpose, just for the talk. I think I'm far enough away from everyone. So it's a real honor to be here for the Richard Childress Symposium. It's an honor to follow all of the speakers of the day. It's an honor to be here in St. Louis. I took a trip out to the Arch, and it was fantastic to see the statue of Dred and Harriet Scott facing the Arch as I faced the task of coming here to speak to you. So that was a great and moving experience. I'm going to talk about abolition. Abolition instead of compromise. We should abolish the prison system and replace it with nothing. Critical race theory began as a Jeremiad. The harvest is past, the summer has ended, and we are not saved, is how Derek Bell began his first book on the permanence of racism. The harvest is past, the season is ended, and we are not saved. There's a sense of the party already having happened, the train having already left the station. A belatedness is settled over the room that's now filled with a hysterical repetition. The thing that happened actually happened. History really took place despite what the GOP says. History happened, and history happened in a way that haunts the present, that seems to have condemned us to repetition, right? We seem stuck inside history. The time is out of joint. We keep repeating patterns. We think things have changed. We're told things have changed. We're told that things will definitely change almost next week, next month, in 40 years, maybe, who knows? Keep struggling, keep the faith. Sisyphus, roll the boulder back up the hill and be a hero. And that's how it should go. When we bury people, we bury them, not really out of sight, because they're always on our minds. We bury people in concrete prisons, right, behind bars of iron, away from their fellow human beings. And we count that as progress too. We're going to reform them, we say, and their reform is homologous with our reform. The way we reform those lost souls is the way we will save our own, we say, and we don't pay attention to the way we reform those lost souls, which is by using their bodies, most of which are Black and brown, to reproduce recidivism. Like, we will take you off the streets and make you a person we want to take off the streets even more. And we will make you a person who will infect more and more people with the kind of thing that will make us want to take you off the streets even more. And we will call that progress as we bury our heads deeper in the dunghill where all societies, said Aimé Césaire, all decadent societies sing their final swan song. So this is terrible, right? This kind of repetition means something has gone wrong. We are ghosts in the attic of some bizarro world constitution drawn up by a group of horrors, the founding fathers. I condemn them. So if somebody out there wants to say critical race theorists condemn the founding fathers, I condemn them and anyone who listens to them. If I told you that this nice tie was made by a family trapped in my basement, and I will beat them and kill them if they don't make more ties, but I treat them nicely. I get them pizza on Friday, tacos on Tuesday. You would think me a monster and you wouldn't listen to anything that I've said. Precedent builds into our legal method like this idea of stare decisis, builds into our legal method this bizarre impulse to go back in time, back in American history. Why would we? Prior to 1967, the Supreme Court, per Justice Ginsburg in her dissent in Adirondack Constructors versus Pena, had given its full approval to the doctrine of white supremacy. Not until Loving versus Virginia in 1967, a year I remember, did the Supreme Court remove its stamp of approval from the doctrine of white supremacy. So what is in those legal materials before 1967 that's worth paying attention to? Who among the founders that were all either owners of slaves or people willing to break bread with owners of slave and form a republic with them, what in their thoughts is anything any decent person should ever turn to? And why on earth have we built this into a legal system that is supposed to determine not just the future, not just the present, but the future according to these lights shown on it by the past? And those lights aren't lights, they are shadows. Shadows of sadly not forgotten ancestors. So this is the present crisis, right? Backward. It's hard to understand the present crisis because you need to critique to understand the present crisis, because the way you've been taught to see it with unseeing eyes, the eyes of the dead, right? These dead white men pressing down like nails, coins on closed eyes. James Russell Lowell, backward look across the ages and the beacon moments see that like peaks of some sunk continent jut through oblivion's sea, not an ear in court or market for the low foreboding cry of those crises, God's stern winnowers from whose feet earth's chaff must fly. Of those crises, God's stern winnowers from whose feet earth's chaff must fly, never shows the choice momentous till the judgment has passed by. The choice momentous right now is to become willing tools of the superstructures, or to have faith that if a thing is right, the thing is possible. And if the thing is possible, the thing should be done. And can be done by us in our lifetimes, not in the never, never, not in some far-flung future, not on appeal to some life that you're never going to live. Once you do that, you are the dead, right? Once you say the win isn't going to come in the here and now, but it's going to come later, far from now. You've been to the mountaintop, you've seen the promised land, but we're not there yet. Well, we should be there now, and we should have been there before, and to compromise on that is to compromise on everything. Truth forever on the scaffold, wrong forever on the throne, yet on that scaffold sways the future, and behind the dim unknown standeth God within the shadows, keeping watch above his own, right? James Russell Lowell, a person quoted often by the Reverend Dr. Martin Luther King. The way we keep watch on our own is, or should be, the way God is said to keep watch upon his own. In the here and now, the Gospels, according to the Christian tradition, and although my middle name is Paul, I'm not here to deliver a sermon, although I guess I am, because I said critical race theory was a Jeremiad. So I'll just lean in to all those Sundays I spent in church because my parents ordered me to go. I was literally a prisoner for Christ, and when they, like the Apostle Paul, but when I pointed that out to my parents, the dungeon didn't shake, right? My dungeon, the very first time I thought I was lost, my dungeon shook and my chains fell off. That didn't happen for me, but maybe it can happen for mom and dad. Kept bringing me there. Dad didn't even go. He just had mom bring me. Well, we know how to do things, right? Food for the hungry, water for the thirsty, hospitality for the refugees, clothes for the people dressed in rags, healthcare for the sick, and for the imprisoned, freedom from the abomination of desolation. We know how to do them. We know we're not supposed to do them just singly, just alone, as some kind of private little enterprise. We know we're against private enterprise. We reject the 30 pieces of silver that private enterprises give us. Yes, I'm a communist in a Matthew 25 sort of way. So go ahead and run tell that. Sorry. I'm amusing myself here. Run, tell that. It's when 2 or 3 are gathered together in the name of the hungry, the thirsty, the refugees, the homeless, the ones in rags, the ones who are sick, the ones who are imprisoned and need a visit to escape from the abomination of desolation, that things can happen. But we can't make those things happen as long as our heads are buried in the dunghill, as long as we're looking back at precedent, as long as stare decisis has blinded us to the truth of that kind of good news, that it is possible to do the right thing in the here and now. So if we're blinded to the truth as a matter of legal method, that legal method has to be interrogated. But if they tell us that we're afraid of too much justice, so I have to drop the McCluskey parts of my talk, too much justice, and that's a problem. So doing the right thing means doing it institutionally, means gathering together in 2 or 3 or more to do wonderful things and having faith that that's possible. Faith is the substance, we're told, of things hoped for. Faith is the evidence of things not seen. So is critique, comma, goddammit. So is critique. Here's how critique shows you the substance of things hoped for and the evidence of things not seen. Critique shows you ways in which you have blinded yourself. Critique is the scales falling from your eyes. Critique is that moment that you change, right? That moment that you change. Now, but for all this anti-communism stuff, I'd have gone to Marx and talked about dialectics and ways in which you change. You build the road by walking, you become something different as you are making the world different, and so it's possible. Instead, I will say something a little bit milder, more in touch with the Bible Belt, if you will. Can I say that here? Right, that's not name calling, right? That's a thing, isn't it? So, sometimes the way you are living blinds you to the way that you ought to be living. So Saul of Tarsus was doing one thing, the scales fell from his eyes, and then he became Paul the Apostle, my namesake. The Immanuel Kant, let's take it to another level, tells us that all those puzzles that philosophers had dealt with, like time and space and all those contradictions. Well, where's the first period of time? When would the last period of time be? How does Zeno's arrow ever hit the target if it's got to go through half the space, half the space, half the space? And these things go on endlessly, don't they? We puzzle over these dilemmas. This is the way we like to puzzle over things, call them paradoxes, like, how do we free the prisoners? How do we free the prisoners? How do we free the prisoners? What would happen then? What would happen then? What would happen then? We can't do it. I can't figure it out. It's so hard to do the right thing. It's impossible. I've been to the mountaintop. I've seen the promised land maybe one day, but not today. So how do we get out of that? Well, we get out of it maybe by critique. Space and time for Immanuel Kant aren't things in themselves. That's why they're so puzzling. They're just the way we need to see things so that they can be things for us. We're constructed in such a way that we perceive things only by enveloping them in time and in space. Those are ways of our understanding, not things in themselves. Problem solved, moved on. Critique is beautiful. Other critiques are also beautiful. Transcendental knowledge is really groovy. I'm bringing that word back. My students aren't having it. I use it 3 or 4 times a day. So it's kind of a 1967 word, like Loving versus Virginia, or the Jimi Hendrix Experience, or the beginning of when we should ever be referring to anything in the American past with some kind of automatic reverence, if ever. So transcendental knowledge is how it's possible to, ordinary knowledge is knowledge of an object. Transcendental knowledge is knowledge of how that object becomes an object for us. Like it's a structure of looking at what's in our heads. What is it in our heads that makes a certain thing a thing for us? Time, for example. They tell you time is past. You think time must always be passing. You might be thinking, when is he going to stop speaking? The time is interminable. Or at least it feels so phenomenologically. Time, slavery to segregation to neo-segregation. Professor Farley, we've made such progress, slavery to segregation to neo-segregation. But I will tell you, in the mode of critique, Slavery is white over black. Segregation is white over black. Neo-segregation is white over black. The movement from white over black to white over black to white over black isn't progress. In fact, since slavery is death, death only, and that continually, and the prisoner, according to the Supreme Court, is a slave of the state, then this movement of slavery to segregation to neo-segregation or new Jim Crow, this movement from white over black to white over black to white over black, isn't movement at all. It's the motionless movement of death as it perfects itself in our heads. This beginning for us begins bathed in blood and covered in dirt, right? The modern era begins with the genocide in the Americas, colonialism in India, the conversion of Africa into a commercial hunting ground for the gathering of black skins. Oh no, I've done it. I've cited Das Kapital, Volume 1, on the beginning of our timeline. Law comes in to tether people to property, and the law pretends that those tethers linking people to property aren't really just linking people to each other in a really perverse way. The property owner, the first capitals are accumulated with slavery. Uh-oh, that tells me 1 minute. That's groovy. The first capitals are gathered through slavery, genocide, and colonialism. If the law tethers people to property, that is, if it tethers people to the means of production and tethers others only to themselves and their labor power, then it's really just an arrangement between the owners and the workers. And there's nothing to be reconciled between them except the abolition of the market, which I believe we'll be able to see our way clear to do with critique. When the scales fall from our eyes, when we who see but dimly in the present what is small and what is great, slow of faith, how weak an arm may turn the helm of fate, we'll figure out, that's James Russell Lowell again, I'm not so groovy as to have those words as my own, but I'm groovy enough, fourth time I've used that word, to find it there. There's a scene in the Gospels. I think it's the only miracle repeated in all four Gospels of the feeding of the multitude. And some people present that scene to you as a cheap trick. Watch me pull loaves and fishes out of my hat. Presto changeo, the hungry are fed. And that way it turns you off of the true miracle that you have experienced in your life, the miracle of altruism, that if you're still human inside, drives you more than anything else. That spirit of altruism says that sharing, perhaps in an Epimethean way, let me just share and not look backwards. Sharing always produces enough for everyone. The miracle is you reach into your basket, you take what's there, you share it, and suddenly the multitudes are fed. You reach into prison and you resurrect the dead, like Lazarus, and suddenly there's another miracle. The people who were gone are here. The prodigal sons and daughters are returned, and it's time for a big party. And that big party may be us finally looking at our loves, labors, not lost on a prison system and a juridical system that can't take cognizance of them. It's us having a party for ourselves, because we ourselves were lost as long as any one among us was, and there is no place more far gone from us than the societally imposed exile, internment, and death that is the prison. Thank you.
Outstanding presentations. How about one more round of applause for our presenters today? Very good, thank you. At this time, I'd like to ask you to come forward if you have a question for any of the members of our dais here. Questions?
I have a microphone.
Okay, Professor Flanders.
I'll ask a question. I have a question about algorithms. With algorithms, it's always compared to what? And so if you're removing algorithms and just leaving human judgment, does that, at least with algorithms, they're transparent. We know what sort of inputs we're putting in. With humans, it's just sort of a kind of a mystery, but we do know it does have also bad results.
Yeah, so I think that's a really interesting question, and it's important because one of the arguments made to those who are critical of the algorithm project is, well, why should we, allow just regular decision making when we know regular decision making is racially and socioeconomically biased? But I think what's really critical is to think about current algorithms, because we could imagine, an algorithm is just a recipe. We could imagine creating algorithms that took into account data that wasn't primarily or even at all based in the data produced by the criminal legal system, and those algorithms might produce different outcomes. But when you have algorithms like we currently have, which are exclusively built and trained with data produced by the criminal legal system, we actually have a situation that's a bit worse than just having decisions by, and I'm talking about this in the pretrial context of bail judges, because of the fact that bail judges sometimes take into account data that isn't produced by the criminal legal system. Sometimes they'll take into account the fact that a defendant is the primary caregiver of a young child and use that as a reason to release the defendant, even though they might have a risk of flight or pretrial crime. And you don't have that with pretrial algorithms. So I think that in thinking about what pretrial algorithms are doing, in my view, they're not an improvement because of the fact that they essentially take this data that we already know is racially and socioeconomically tainted and push us towards predictions that will, because of the fact that built with this data, be also that tainted. And while we're concerned about individual decision-making, the very fact that individual decision-making could be swayed by other factors is something that pushes me to feel that as though the current algorithm project is worse than what we have.
Very good. Questions? This is a great opportunity to avail ourselves of a bastion of knowledge here, so.
I got more questions.
Okay. We'll just let you ask all the questions.
Good to give you the mic, I guess. David, my worry with arguments is it isn't the way it's framed. It sounds like almost like, well, then we should level up, right? Because sort of leveling up versus getting rid of the death penalty. Because like, okay, so to show respect for you've heard my question before, so you can maybe ask it better yourself and then answer it.
Right, so is the bottom line, well, let's just execute everybody because that would be fair. No, you're right to say that the natural response to there's a disparity in the valuing of victims is, well, we could maximize penalties and we could even this out. And what we're asserting is that this fits in a larger, legal landscape where, African-American lives are less valued in civil disputes, and that African-American, experience and freedom is less valued in administrative decision making. And so ultimately, we make the case that there's an always and everywhere disparity in this level of sentencing. So you don't make it fair by making it worse. You make it fair by abolishing the death penalty, which, as I said, several states, New Jersey, Connecticut, Maryland, have directly acknowledged they have racial disparities and answered those racial disparities by simply ceasing to use the death penalty.
Go ahead.
It's a question that you basically use for. The sort of, the abolitionism of the moment is and in many ways, recently, at least the sort of mobilization around it has been about prosecutors and about the sites of prisons themselves. Is there an abolitionism that focuses on the courts itself, the courts themselves, and what would that look like? If that makes sense? Are we leaving the courts out as we attempt to tinker with these things?
Oh, well, this is actually an answerable question.
I think the existence of law and of state power is an example that is evidence that the society has come across an objective contradiction that it refuses to solve. Right? So I think you look at humankind's maturity will, I think, if we ever get there, if the 22nd century is on offer, which seems not to be the case according to the latest and most reliable climate studies. But if there's to be a human future, then it is one, I think, in which you won't find groups engaging in practices like state or private power, where somebody monopolizes the use of the quote unquote legitimate violence and gets other people to comply. You'll find a culture that installs a willingness to help others out, to feel other people's crises as their own concerns, and people who form institutions around that kind of enabling. So it may be we just don't have ears to hear the critique of state and the kind of private power that is also state power but masquerades as private enterprise. We don't have ears to hear that yet, but I think that day could come. I guess think of it this way: everyone gets assigned Orwell's 1984 in America, right? And you read it in 8th grade and think, "Wow, Stalinism bad," because Stalinism is bad. But people don't read Homage to Catalonia, right? Because then you might think, oh, so Orwell's critique of totalitarianism is because he fell in with the anarchist communists in Spain and abandoned his Communist Party affiliations for the actually existing anarchist communism that was happening in Spain in 1936 before it was crushed by Franco, whose book, by the way, Donald Trump was following to a T. Right? It wasn't a Mussolini book, it wasn't a Hitler book, it was Franco. And Franco, as many of you know, but you didn't learn in high school in America, died an old man in his bed. Oh, and after having been a dictator for 39 years in Spain.
Any other questions? Okay, if there are no other questions, I'm going to ask Professor Flanders to come forward with our closing remarks. Thank you.
Well, so thanks, everyone. So the closing remarks are kind of a disappointment. They're just more thank yous, which you've heard before, but I think that they ought to be made. So thanks, first of all, to all of you for attending and participating. Sorry I didn't get to all of your questions, but thanks for being part of the conversation. And of course, thank our keynote speaker, Angela Nwachi-Willig, for her wonderful address. Thanks again to all of our panelists, Danielle Conway, Mario Barnes, Christopher Tinson, moderator Richard Middleton, David Niven, Ngozi Adikidbe, Anthony Farley, and Belinda couldn't make it. I want to thank especially Dean Johnson. He's been praised repeatedly for his vision and leadership. I want to just add my praise to that. Thanks to Miriam Cherry for introducing our keynote speaker. Thanks especially to the Law Journal staff and their very hard work. I have to single out again, Dylan Ashdown, the Childress managing editor, and Jenna Colson, the editor-in-chief of the Law Review. Thanks again to Christopher Tinson and the African American Studies Department for their support. And I know I echo a lot of people in this room saying that I hope this is the first of many collaborations in the future. And finally, last but not least, thank you to Susie Lee and Julie Orr, who work tirelessly behind the scenes year after year to make conferences like these possible. So thanks again for attending, and that concludes our symposium. Good job.